having some better logo. Yeah, that's good. I forgot my. That's really that asking for it. Yeah. Is closing the East 81 goes. You got a regular podcast on your hands in that game? I have that in my children, I admire that. Okay, yeah, for sure. I love the golf course out there and go back to
We're getting close.
how long did you keep it?
All right.
Good morning, everyone. We are now on the record in the Sumner County District Court. I have a Zoom application up. That's only for YouTube purposes. That is not recording. And Ms. Hamilton is taking the official recording of the proceedings today. We'll call cases 2017 CV119, 2017 CV118, 2017 CV117, Mid-Kansas Electric versus Klossmeyer, Meyer Revocable Trust, Andra, Ford, other defendants. Counsel, your appearance, please, starting with Mr. Travis.
Plaintiff appears by and through Travis K. Jones from Watkins County Shire, Your Honor, in all matters.
Judge Paul's appearing on behalf of defendant Florix, 117 case, Austin A. Paul appears.
Your Honor, please, Chris Maplican here today representing the Andre defendants in case number ending 118.
Your Honor, Brad Stout and Robert Kaplan, appearing on behalf of the Meyer Trust and the Meyer Trust in case 119.
Thank you. Matters on the court's docket this morning for argument in support of the parties' respective briefs. Case has been in existence before this judge was on the bench. Through the course of some hearings, be it pretrial motions or pretrial conferences, court had certain questions about the underlying documents in the administrative proceeding, that being 2017 CV118. Of course, concern was how to make anticipated jury trials and the questions presented to the jury as consistent as possible with the underlying administrative procedure. In that effort, reviewing the documents, it had some questions about some information and descriptions and notices that culminated in the court filing an order for briefing. And so on March 28th, asking certain questions. Some of those questions were from Supreme Court rules dictating controlling pretrial conferences within the domain cases. Then further questions from the court for clarity purposes of the parties' positions and what might be appropriate at the end of the instruction. Jurors would be anticipated jury trials. So the briefs have been filed, of course, viewed all briefs, more than one. They've viewed at least the cases insofar as what is cited, but for most purposes, the cases in their entirety. From the outset, Mr. Turnus raised, and there were some responses to perhaps the posture of the case as it is right now. I think everybody can agree it's unique, but there are pretrial orders filed in the cases. So I guess we should start with that in an attempt to prove. Mr. Turnus, I'm glad you made the record on that limited initial issue first. If you have anything outside of the brief.
Think you're referring specifically to my arguments based on waiver latches and estoppel.
Correct, and if that has implication on, I mean, despite what the court decided on that, whether that has implication on whether you think the court's appropriately hearing these motions or briefs and questions today, we can go into that.
I don't have much to say outside of my brief, which made it clear, I think, latches bars any arguments that the entire petition and these proceedings are void. I'll rest on my brief.
Just thank you. We have a consensus of counsel as to Ernie's how we go with that numerical. Is that left or right?
Yeah.
Okay. Mr. Baldgrip, I think you're the default lead in any position you'd like to put on the record outside of the brief on issue pretrial orders, waiver latches, etc.
Well, yes, in the beginning of all that, the reality is no trials have occurred herein as relates to any of the parties that you should. As the court's aware and pointed out in the Andrew brief, the courts always have the right to allow amendment pretrial. And that applies to all of the defendants. In addition to that, the record was clear that, for example, as a court, this continuing issue that we fought since 2018 as to what this even entails the purposeful ambiguity of the easement has been squarely an issue at its core, and specifically, the court, the scope of the taking issue was such a sliding, ambiguous thing for Sunflower that the record clearly reflects that December of 2018, the Andrew defendants, after getting discovery responses from Sunflower, and after having sat through the deposition of Mr. Fuller, or before and after value estimate, that there absolutely was no clarity as to what the scope of this taking was, which triggered what? The motion to dismiss. We argued that Nina, the prior trial judge in this file, who ruled against my clients, and as cited in our briefing, by law, we couldn't take that up on the interlocutory appeal. And again, as reflected in the pretrial order, we specifically reference this issue under question of law that there was this continuing effort by the condemning party to redefine and to broaden, in its case, the scope of the use. And so we've proved, I mean, it's maddening. It's maddening given the record to have to stand here and argue that latches and stop, etc., in some way apply to these parties. We've been, and we've already warned on this on the TV station, but we have fought this for years, and we fought it for years solely because of the mischief created by Sunflower, formerly Mid-Kansas, by its intentionally ambiguous draft that it has taken advantage of at every turn and cited in the Kansas in front of this board. And I don't know what more we could have done to preserve this issue.
Mr. McElveen?
Yes, Your Honor. I take a little bit, I have a unique position in this case as far as the collective wisdom and experience in condemnation matters is abounds. And I bring the IQ level down as soon as I walk in the courtroom. But I kind of liken my perspective in coming into this case late at the point in time that the pretrial orders had already entered. Liken somewhat to your we both came to these files. You had a much bigger job because you had ongoing matters in some of these. But all the damage had been done by the time that either you or I started to focus on this. And you spent a lot more time than I have, and I appreciate that. But, and I expressed to Mr. Turnus, for the life of me, I couldn't figure out what was going on in this case. I could not figure out exactly what the positions of the parties were. It was very difficult for someone to look at what should be a fulsome record at a time in these proceedings that the only issue should simply be what is fair and full compensation. What we had was more litigation and argument trying to parcel out what was the scope of the ingress and egress easement as well as other issues. What part of the larger tracts were burdened by that, and what were the consequences? And could the condemnor come in and present evidence on this very loaded and pregnant term reasonable? And it wasn't until that I went through this process that I finally came to understand what was going on. And what happened is that we date back to the problem with the description of the taking that began at the very beginning. And you put the landowners in a horrible position that they had the least amount of resources to conduct this battle. And so I can see, putting myself in the shoes of my prior counsel, they're trying to figure out, what do I do to this? What is the most efficient way I deal with this? They may have not figured out everything, but you can see the efforts that they made, even going as far as the one track, trying to come up with some type of legal description. And which I believe Judge Mott just sat down and kind of did it himself for the best I can tell. And so I think that you should look and say, who had the ability to cure this problem? Who lit the fuse? And it's the Kidem North. And the parties should not, at least in any of the cases, but especially in my case, where the council is struggling and trying to balance it. And knowing that my clients are using up their award by at trying to litigate this. So there is no reason why that you should say that there were latches, waiver, or estoppel, simply because the argument may not have been completely framed as a void taking. You, as Mr. Paulcraft said, have the absolute discretion to allow amendments to the pretrial order. All orders in this case, all rulings, everything that's happened to date in pretrial is interlocutory, subject to you taking control now that you've done an entire review of these matters. I would submit that, and I'll get into this perhaps later unless it's touched on council. What are you conditionally mandated to do? I submit under the case law that if you have one particle of discretion on any decision, if you have one iota of discretion as to any ruling or action today, that the guidance that you receive from the Supreme Court is you to exercise that discretion strictly in favor of the landowners to protect them and ensure that they receive full compensation, because all the power is in Sunflower's hands to control the conduct of this case in Central. And case law is very clear. Justices are concerned. We're trying to figure out a way to make sure there's not either intentional abuse or reckless ignorance or mistakes on the party that controls the proceedings that hurt the landowner. So you have the discretion to do it. I think under the circumstances that you have full discretion and should exercise that discretion in favor of the landowners. And as I read the case law, any consideration of latches, estoppel, or waiver, there's no waiver until there's a final judgment. And as the preacher says, that's when there's a death to all arguments, and with death comes justice, and that's where things locked in. Until then, you have complete control to correct and make sure everything is done correctly to protect the landowners. And all you're doing is holding the Sunflower to its duty to make sure it scrupulously follows the procedure. Because I'm looking at this, and from my perspective, again being the newest eyes in the file, what they created was a Hobson's choice riding on the top of a Hogan's goat. The Hogan's goat is the mess that was launched in this case. The Hobson choice amongst the landowners is, what can we do given our financial burden and the fact that we don't control the proceedings. So I'll sit down, but I just say that you could rest easy, Judge, that you have followed as an initial threshold, have satisfied your duty to protect the landowners as constitutionally mandated, to reject this waiver argument and let this matter go forward, be corrected, and go forward on a fulsome, complete record.
Thank you. Mr. Stout, and going forward, when I get to your clients, I'll start with you, but if it's something Mr. Kaplan's going to cover, all you gotta do is let me know that.
On this issue, I don't believe Mr. Kaplan will be correcting my statements or improving on them. And Your Honor, let me limit my, to the extent any comments were made, they were consistently processed condemnation action. All tracks are essentially subject to the same definition and description. The suggestion that there was any sort of a waiver with respect to the description problems is false. It was simply transferred to a different method. If we went into the pretrial, as you mentioned, the Supreme Court rules require that we define the entire property immediately before. So those rules, we are required to define the extent of the taking. But to the extent we even got to that point, there was what little agreement, and then what we see in some of the description is the ability to manipulate it. That's what our concern is. So when we were headed into trial, what we were going to see is witnesses testify to a more limited use. Access doesn't problem. What they built is fine, but the just compensation is determined on just compensation is determined on what they took, not what they used. But we were headed into trial, in which there would be repeated objections and other items, all were focused on these same issues that we're raising today. So there was no way, there's no problem. And with respect to the unique issue that arises for Meyer, which is the track 13, it was at one of the pretrial hearings where I got up and explained, we'd just been exposed to track 13. We alerted the court to the fact that we didn't know exactly what all that meant because we hadn't studied it. Well, now we have. And to suggest that we waived it when we took extra time to explain the court when we weren't again sure what the remedy was, is an inappropriate allegation. The court can't dismiss anything today on those arguments. Last point, doesn't matter. You don't make something that's constitutionally invalid valid by not raising something in a pretrial. The Fifth Amendment to the Constitution says two things. We are entitled to just compensation, and we've been focused on how do we get there. But it does something more than that. It says that no person will be deprived of life, liberty, or property without due process of law. So the constitutional provision we're really talking about today is there's all this, Mr. Baldrop called it mischievousness, which is just too rich not to enjoy again. There's all this process amount to a constitutional due process. The Eminent Domain Procedure Act is Kansas's attempt to ensure that that due process of law is provided to every claimant. If we don't meet that, we haven't satisfied those, then it's unconstitutional. That's what we're talking about today, and that wasn't. So I adopt our co-counsel more spirit, more insightful arguments, but I would also say supported not precluded from considering these issues on any of the flashes or shop arguments. In fact, to do so would be appropriate. Thank you. Thank you.
This furnace, do you agree that or at this point in time, amend the pretrial orders or simply set them aside for purposes of proceeding to allowing the argument?
Your Honor, I do believe you have the authority for good cause shown to amend the pretrial orders and your leisure, your discretion. If I may be permitted to briefly respond to my other counsel's argument. I'd like to point out Mr. Baldgraff's motion to dismiss, the motion for summary judgment, never mentions the word void. They never ask the void to petition. More than that, it is strictly about the ingress and egress and whether Mid-Kansas could put on evidence of how they would access certain property on the larger properties. He was granted an order in limine by Judge Mott. This was ruled on, it was done, the order in limine is what was granted. He never asked to void the entire proceeding. He never asked to undo the entire proceeding. He wasn't harping about bad faith or abuse of discretion at that time. They took your briefing as a suggestion to turn the entire proceeding into a motion to void the taking and an argument for bad faith. That was not preserved by his motion for summary judgment. It is not mentioned in any party's pretrial orders. While I acknowledge you have the discretion to allow them to amend their pretrial orders, good cause and the due justice, pretrial orders are there for a reason. You're supposed to state your entire theory. You're supposed to put forth all of your arguments. And they control the case from that point forward. You want to allow them to amend, that's all right. That's your discretion. But the argument is still there that latches apply. Nobody raised the argument to avoid the taking until after the pretrial. As it relates specifically to track 13 and the Meyer and Klausmeyer defendants, the petition has not changed since 2017 when it was filed. They found out about track 13 by reading the petition. The petition that they had since 2007. Counsel that represented them in the administrative proceedings still represents them today. He acknowledges that he signed off on the administrative orders, his signatures on all of them. They never raised this issue until this year. My argument is still that latches waiver bar than raising this argument now. They aren't left without remedy. We've all had appraisers value the property. Every one of them has an appraiser that will testify to value. More than that, the appraisers below value the property based on what the petition says. They came to a value. The jury's going to get to hear appraisal values and come to its own decision as well.
Wanted to address the pretrial orders or getting into too much of the meat and substance of why they're here today. But I suppose this question assists both. Your brief certainly asserts that the defendants should not be viewed as helpless. That's fair. But I wondered and was going to ask what is the extent of any duty of a landowner that is affected, implicated, read it in the newspaper despite any other notice. That's just a toss in there, not something that's necessarily any point of contention. Anybody knew about 2017 CV158. What do you believe they will require to do going forward? Make themselves known, their interests. So is there a limit that or a bookend you'd like to put on the record about that?
Certainly, I'm not here to talk about any hypothetical landowner who may have seen this publication of it. Just talking about the defendants in this case, they had an obligation to raise this at some point within a reasonable amount of time. We're sitting here 5.5 years later. This is strictly a judicial argument. There were no jury trials allowed from March 2020 on for these cases until 2022 when we had them set again. At any point during that roughly 2-year period, any one of them could have raised it. They could have raised it earlier. They were represented by counsel, and the defendants in this action who were represented by counsel could have also raised it in the administrative proceedings. Mr. Kaplan filed multiple motions. He had input on appraisers. He had input on judge instructions to the appraisers. He could have raised it then. He's the guy who set the case law that lets you void a proceeding. They have to act within a reasonable time pursuant to the Supreme Court case law. You don't get to sit and wait to exercise your rights while somebody else goes out and builds out property, spends money, and exercises the rights that they were given under.
That my question is probably bad and get ready for more of those today, but your answer doesn't go far enough back to what I was intending. If sum up for me why Klausmeyer and Meyer, well, did they have a duty because they received a copy of the petition and knew about these tracks 8 and 10, I believe, that they were supposed to read into other tracks that didn't name them and come to mid-Kansas at the time and say, you have the wrong landowner? If so, where does that go?
They had a duty to raise that argument before the day.
I understand, but do you think that could have happened in 2017 CD 58?
I did.
And why is that?
Because Mr. Kaplan's filing a motion in 2017 CD 58. He's not shy about it. He asked for instructions specifically to the judge. He's weighing in on appraisals. Moreover, the argument is essentially, we acknowledge that we got a copy of the petition, but we didn't read the full.
Why do they have any duty, however that is phrased or classified, come to mid-Kansas and say, you're not, in essence, this isn't correct, you're intending to take this and you need to name me? Why do they have to do that?
Because anybody sitting on their rights, when they know about it, has an obligation to raise those within a reasonable time. I'm stating for the court that 5.5 years later is not a reasonable time.
Give it one more shot for my purposes. Your client controlled what rights they were going to take.
Correct.
Your client's in charge of that process. At what point did any of the defendants have that they were supposed to make sure those duties are carried out appropriately or correctly? The underlying administrators.
Certainly before your attorney agrees to a signed order authorizing the petition.
Any authority for that, that says what the petitioner's duties are, that defendants after receiving the petition should do this.
I have no case law outside of what was cited in my brief for that matter.
If something about the underlying administrative proceeding was less than full, does that play into the argument of an estoppel waiver and lapses? Meaning, if the defendants didn't have full, complete, label it how you will, notice what was going on, could understand what was going on in 2017 CD 58, and only know or have notice, understanding of it in this proceeding within the last 6-12 months, whatever that is. Do you think those are different circumstances? How can they be charged with knowledge for 4 or 5 years of something if the court agrees, or if the court does agree the petition was something less than what should have happened for either description or notice proceedings? Somebody with 5 years notice has more opportunity than somebody with 6 months notice is kind of a summary of that.
Okay. The summary helps clarify. Thank you, John. I believe the last two sentences of KSA 26-502 and 503 really speak towards the remedy, meaning that no defect in form and no defect in notice shall invalidate the proceeding. You're talking about a defect in notice for Mr. Cloudmeyer, strictly as a farm. That's the facts that we have in front of us today. He had actual notice. His complaint, really, I just didn't have constructive notice. But assuming you have a defect in notice, it doesn't invalidate the proceeding. Voiding is akin to invalidating the proceeding. No defect in form shall invalidate the proceeding. The statute is pretty clear. We give construction to the document and we try to uphold the document that we have in front of us as best we can, rather than void.
And defect in notice would be something different than no notice, is that correct?
Yeah.
And so the middle ground between our previous question and these questions would be, why did Bossmeyer have to go read the entire petition, even in the tracks that didn't have him named, to determine whether he owned or had an interest in that ground. And report that to mid-Kansas and then advisors.
To make that argument now, he had to bring it within a reasonable amount
Of when, I'm sorry. It's a reasonable amount of time of when.
he had to bring it before filing afterwards, that's not,
I'm trying to see why you say 5 years. Because he received, you believe he received actual notice of track 13 for the most contentious part of the rest of it.
yes.
I received a copy of the petition.
Not only that, his attorney admitted that the surveyor told him that we were condemning that as a separate track.
In surveyor spoke for the petitioner.
Surveyor told him it, and the petition confirms it. Worth noting that he's not making the same argument as the farm tenant for track 10, which is the farm tenant for track 10, which we're in minor owns. He's not asking for any compensation as the farm tenant for that.
Is it possible, at least for procedure today, that the court address the pretrial order and reserve your argument on waiver of estoppel and latches?
I presume that would be what you did.
Yes, thank you. Any counsel would like to respond to the inquiry or attempts of clarification, Mr. Burns?
I don't want to do a lot of back and forth with the cover our brief, but again, it's frustrating. We didn't use the word void in 2018, we used the word dismiss. We used the word they should have to pay our attorneys because of the same issue, separate from the trial 13 that you need to fire clause. Same issues that bring us here today. We made that argument. Secondly, we had specifically reserved, and the court goes back and looks at its calendar, we had specifically reserved a day on their calendar after pre-trial and before trial to go up to do what? To go back, that I requested on behalf of the Floridas, to go back and revisit the prior rulings from the prior trial court on this case, which is conveniently being left out. So we've argued this since 2018, and yes, I'll stipulate we didn't use the word void, we used the word dismiss. We're precisely the same. That brings us here. And on top of that, we not only preserved it in a pretrial order, we also said, let's go back, set a court date, to revisit these prior issues. I don't know again what else we could have.
Your preference on amending pretrial order or setting it aside? If the court has to do that, one of those.
Well, as long as whatever the court does allows us to seek the remedies that we set forth in our brief that we think are appropriate, I don't care if it's a new order.
Matt, yeah.
I echo Mr. Paul Kraft's point on that. So long as the court imposes an appropriate order to cure the defect. How we get there, as long as that substantial justice is done in favor of the landowner. You have broad discretion. You have broad discretion to actually, it came to me last night, what is essentially a kind of a status quo injunction to make sure that everybody's protected, but still preserve substantial rights for the landowner. I come back to something a little different. Case law says it is, and what is left out is that no defect of form which does not impair substantial right of the parties shall not validate proceeding. Case law is clear. If the description of the taking is inadequate, the proceeding is void. Now, how the court executes or manages that in the course of where you're at the proceeding is up to your discretion. But in looking at, I believe it's the city of Wichita case, it talks about this is a subject matter type jurisdiction argument, which can never be waived. Subject matter jurisdiction, subject matter issues can be raised at any any time, and I submit up till the time of final judgment when the parties are locked in. Allowing the court to pierce the pretrial orders and the other interlocutory orders that are always subject to this case. Good cause also applies or requires an analysis that there's no undue prejudice. Well, there is no undue prejudice to some part because you're basically saying, go do it right. Go do it right, clean this up. You have the obligation, and Your Honor, you shouldn't have to get into these matters to determine who did what, when, and where, because again, if it's void ab initio, and then you have to decide in your discretion what other rulings take place to manage that. And if the amendment or set aside of the pretrial order or your change in interlocutory orders are necessary to further substantial justice, again, protect the landowners. So I gotta come back to this, all of this kind of doesn't matter. You shouldn't have to be making this inquiry. You should hold them to the letter of the law, that they are strictly required to strictly follow the rules. And if that taking isn't adequately described, then you have the ability to go back and make them do it right. And you have the inherent powers to make those type of orders to bring to bring some semblance of propriety to what has happened and where we're at today. I think the court should also be mindful there, that although the publication notice may not directly impact certain parties in the way that other parties, but the court, I think, raised this in one of our conferences. There's the rights of the public that are involved here. How in the world can anybody look at these proceedings who's going to be a subsequent purchaser of any of this land and figure out what rights am I getting? What's Mr. Paulgraph's title search going to indicate on that? So that's another reason why the publication notice has greater ramifications, because it doesn't clean up anything as far as the real estate records are involved. So that's kind of part of what your role is, to protect everybody and make sure they do it right. So there's no reason to hold anybody to interlocutory orders. Let's get it done the way it should have been done in the very beginning.
Thank you. Mr. Stout?
Yeah, I need to speak to it, even though my co-counsel done an excellent job again. Because those allegations were mainly against track 13, which again, we all know when we discovered it, because we brought it immediately to the court's decision or attention. So as I understand that, now I need a kind of a clarification so I can understand this argument in the full extent of our bad conduct in this matter, and not doing something sooner. So let me see if I got this right. They have the unilateral authority. Not even the court can get into their description in their petition unless we find abuse of discretion or bad faith or something. It's their discussion, right? It was filed in an administrative action, and at that administrative hearing on which that was approved, the court was asked to find three things: that the legal descriptions of what was being taken were included in essentially the 26502 was complied with, that the proper parties were named, and that there was authority. That there was authority stated in the petition what to do. And if those things were in a verified petition, then we went forward. And at that time, someone, I wasn't here, but someone stood up and said, here's our petition. It's been verified by Mr. Stewart, that's Lowry, who said, we fulfill all the obligations. It's right. Or it proves it, we go forward with the administrative action. There's no in-depth what. So from that point forward, the clock starts ticking. And what's it's ticking? It's the obligation of the landowner to find where, in fact, the condemning authority didn't do what they signed a verified petition saying they did. What they didn't do. That's our obligation, right? Mr. Lowry signed and verified a petition that includes the allegation that the condemning authority has used due diligence to identify all the parties, including the parties in possession. We're not asking, ignore the fact that we say we own them. Ignore that. They ignored us as a party in possession. Let's understand the full extent of that argument. Your Honor, this is the northwest quarter of section 31, right? We go track 8, 13, and 10, right? That's what they put in front of the court with the verification of Mr. Stewart at Lowry. And they said this is the right way to do it. What they were telling the court to approve is that the northwest quarter is divided into these signs and in fact includes an area of ground that is owned by 2 different parties under 2 sets of documents. There's an overlap. And in fact, we're going to condemn it twice. This little section of ground may be the most condemned property in the state of Kansas. In this action, it's been sacked twice with these rights. This tract, they said, stands alone. Now they looked at, they were on the property, they surveyed. They went out there and for the life of it, due diligence involved by Mr. Stewart S. Lowry, and said, well, same party in possession. Can't figure that one out. I mean, the fact that it's been farmed by the same person, it has the same crop, it is in a shape of a piece of property that has no useful purpose, none. But we couldn't figure out that that was the party in possession was the same guy on this, and this. So instead, when we condemn this land, our due diligence, our meeting, our standard, which we represented to the court, that we've done the right thing. Concluded the conclusion that we'll condemn this from Mr. Klausmeyer, we'll condemn this from Ms. Meyer, and we'll condemn this nice pie-shaped piece of property for 2.5 acres that has no access to it from a bunch of pests. I wonder if when they got it, they chuckled. What would we own in the northwest quarter? Right? That is what they said is right. That is the status of what exists now because we didn't do it. Think about what that argument is. Their argument is that it was our obligation to catch this. That means their decision to do it this way wasn't a mistake, or if they had ever looked at it, they would say, oh, wait a minute. We should correct this. This isn't the right way to do it. Because after all, the process has been intended to burden landowners or to take property or get a good deal on property, get a good price. I think she's offered $600. No, that's not what the law says. The law says this process exists so that Kansas land can be treated appropriately. When we start out a condemnation action, the scales are level. Right? The scales of justice are level. When it ends, they won't be level. We understand that. But when we start out, it's level. We started out like this, that's not level. And they say, we had an obligation to straighten it out, but they didn't. That means that this is an intentional violation. That means this is what they wanted to do. It wasn't a mistake. We just heard it was our obligation. Because if it's a mistake, if it was the wrong thing to do, then we all have the obligation. We all have the obligation to say something, right? Whoa, wait a minute. Nobody in Sumner County and a reasonable person would think that this is a standalone piece of property. Hold on just a minute. Let's stop this condemnation and do the right thing. And well, Mr. Stout, you're getting pretty exercised about this, but still what? I mean, what's no harm, no foul, right? If you had named Klausmeyer as a party in possession, I'm not suggesting Meyer because she wasn't out there farming. She's an older woman, she's got other things to do with it. The Klausmeyer was. If you had named him in the course of the administrative action, we might have had an opportunity to step up and say, whoa. That is not the right way to do it. It happens all the time. The tracts in a petition are combined to be the whole entire property immediately before. I've got several cases going in Wichita in which that happens. Tracts 4 and 5 are actually the same ownership. contiguous and used for the same purpose, boom, the same track, you should combine it. That's what would happen here. We would correctly define this action. If they had done that, we could have addressed it actually. We didn't know about it. That's true. How did we find out? Well, remember in the petition, each track stands alone. So you don't necessarily have them together and know that there's an overlap and a gap. What happened was we were putting together an exhibit of the entire Foxmire property immediately before the taking, and we see this gap and say, what about the gap? And they said, oh, track it again. They've known about the gap the whole time. They've known about the gap since before they filed the petition. Let me say that one more time. They've known about the gap since before the petition was filed in 2017. They've known about the overlap since before the petition was filed in 2017, and it's our fault for not straightening them out. The solution to this problem is so simple, and we're going to suggest it today. And the solution is this. We think Foxmire tract, which should not include any portion of the Meyer tract that's overlapped. Let's put it over there. This is the Meyer tract. Foxmire tract is the remaining portion. But this is not a proceeding that's resolved title issue, right? That's not going to be in front of the court. But let's do this. With respect to those two tracts, let's name Meyer in each one. Let's name Klossmeyer in each one. Let's invite the Texans to come back up in case they want to make a claim for anything. What happens when we do that? Why is the process, if it had been followed, not the appropriate thing to do? The answer is it would have been. Why? Because we don't resolve title issues during the administrative action. Instead, anybody that has a viable claim, their claim attaches to the award, and we go in and the court will look under 17CV117. It anticipates there is a distribution hearing in each action. So at the end, in 26.517 reads, in any act involving the condemnation of real property in which there is a dispute among the parties in interest as to the division of the amount of the tax appraiser's award or the amount of the final judgment, the district court shall, upon motion by any such party in interest, determine the final distribution of the amount of the appraiser's award or the amount of the final judgment. Sunflower could take the money in and been done with it, and it would have been up to us to resolve it, which we could have done. And that's what we're going to suggest today. When we redo this, name everybody. Let's not leave anybody out. If there's anybody in Sumner County we'd like to name with regard to these tracts, bring them on. Because that is the right way to do it. That ensures that the landowners get what they're entitled to, which is a fair shot. No landowner was consulted and said, hey, would you mind, we're going to take your property. Will you guys agree to allow us to take your property? No, we don't want it. Everyone was brought into this action because law gives Sunflower the right to condemn property whether we want it or not. All you got to do, Sunflower, all you got to do. Follow the process which we've adopted in our attempt to fulfill the constitutional obligation to each and every one of the fair shot. That's all we're going to do. And included in that, step one. Step one says, the petition shall include the authority for the purpose of the taking, a description of each lot, parcel or tract of land, and the nature of the interest to be taken, questionable. Insofar as their interests are to be taken, the name of any owner and all lien owners of record, the name of any party in possession. We're not even asking you to tell us who owns it. You don't even have to do that. Just name anybody who's out. And in Kansas, where somebody's farming the property, they consider to be in possession. And you heard, opposing counsel just say that, hey, that Mr. Kosmeyer had conversations with, the surveyors from Sumner. Okay, fine, he had a conversation. That means there's a dialogue back that says there's a gap. Gap? What gap is it? Instead of saying, no, we can figure this, simple enough, let's just name everything. They said, no, let's do something else. Let's just name the text. Okay? Forget everybody else, we'll just name the text. Let's see if they can do this. I wonder if they got together and said, well, you know, it's been 2 years and they haven't caught on yet. We're there. It's 2.5 years. Oh, that's great. Here's the county record. No gap. These records were available to them. In fact, their appraiser, this is where it gets even more fun. This is clever. Let's do this. Let's have our appraiser use the county assessed acres. So essentially, we'll use this one when we appraise it. Then this one. Okay. I'll bet you we can go. You know, if we not done the pre-trial, they might have got 6 years. How long will we, how long, at what point did this cleverness effectively eliminate our constitutional right? 24 months. If you can't catch us being sneaky, 24 months, we win. No, that's not fair. 30 months. 3 years. 36 months. That's what they're asking for today. We filed a petition, we got by with it, nobody caught us. Because if it was a mistake, it would have been our obligation to correct the mistake too. But that's not what we're hearing. We're hearing that they didn't catch it. So we get it. That argument should be dismissed immediately. Don't even listen to that. There's no rationale. This issue is right. Kosmeyer was denied their constitutional rights because of this. And instead of coming in and saying, fellas, we made a mistake. It's not like we're going to make them tear down the pole, although that we're going to have to. It's not like they haven't spent the last 5 years making money doing exactly what they want. They got on the property, they built the pole, they got everything they wanted. Right? And they haven't figured out our little trick yet. They haven't figured out the overlap or the gap. Dismiss that immediately. Ignore that. The process was not followed. And the result is we've had a landowner denied their constitutional rights. And we caught it before it went to trial. Thankfully, the process ultimately worked. So really, if you want to think about it, it may have taken 5.5 years, but the law did exactly what it's supposed to. It stepped in and it's preserving the constitutional rights of all these landowners, despite what we are now told this morning was the intentional conduct of some. So I'd say this is allow us to go forward. Our pre-trial, this issue is being decided. So I don't know if we need to amend the pre-trial, scrap the pre-trial. I don't care how we do it. We need a motion for me, we make it. Pre-trial would not have allowed us to the trial, right? Their pre-trial would have had this court, would have had the court condemning one piece of property twice. Right? It would have, the court would have been condemning. No, we're ready. Let's take this issue up today, please.
In terms of got no questions, but you'll get a final word on the issue of pretrial orders and favor self.
Very good. Mr. Stout, you know, as usual, makes a very excited argument after they admit in their brief, the deeds create that gap. This is what the deeds created. We followed what the deeds did. I acknowledge the court recognizes there's an appraiser's office, the GIS mapping that has that. Deeds control who has title. That's just law. This is what the deed drafted looked like. It's an inartful deed. He concedes that point as well. And then everybody glosses over, and nobody in any of their response briefs, which they had an entire month to do, mentions the fact that you only have to name persons of possession insofar as their rights are achieved. Not naming people can be a limitation on the petition and who's and the rights issues.
Thank you. Pretrial order. Sort of review KSS -216, and cited in my over briefing. So Supreme Court Rule 140 of the 40 has certain extra provisions to look at and consider in eminent domain cases. Court believes the pretrial order stays within the purview of the court. The intent to good cause needs to be shown for addressing it, modifying it, or setting it aside at the times that good cause exists. And would court has requested information to just set to hear arguments on what might be a statutory defect. Everybody agrees it's somewhat limited on the domain procedure act. There are cases that address that, and so that those defects can be brought up almost at any time, but certainly at more points in time. Substantial right of being compared or affected. Court opened up with comments about also why the court's briefing appropriate before that was in anticipation of instructing a jury. It's consistent. It's to be bound to follow statutes, follow the appropriate precedents. Those statutes and case law say is juries to determine values, but consistent with same information, the underlying administrative procedure. So that's determined. Like, I guess I'll end with this as an attempt to conform to that. So that would be the basis of the conduct for the set aside in all pretrial orders and the cases that are followed and being discussed today. What takes under dividing the issues of whether waiver latches or estoppel applied, and that can be addressed in the court's determination of decisions following the balance of the thing. We will proceed. Mr. Turnus, is it like the topic by topic, case by case, would you like to make your record in full? And then if you want to make the record in full, you want the court to interject with questions, allow counsel to respond at their appropriate time, or should the court reserve questions to the presentation? Hopefully that wasn't too much to run on question, but I'm trying to be as fair as I can, considering the number of issues, the number of cases that you're having to address. Do you have a preference for that?
Your Honor, my preference would be, I have some things I'd like to just address that are specific responses to new topics raised by the defendants groups that I didn't get a chance to brief. And after that, I have no intention of taking your entire time to repeat my brief. If you have specific questions beyond that, gladly answer as best I can. And I'd just like the opportunity to respond. So I'm going to have a lot of arguments with these gentlemen, so you know that.
We will end on the brief, subject to questions the court has about the brief. We'll make a record about things you believe you didn't brief, because you didn't see it until after the brief was filed after yours. Correct. Soon, often you want to respond to anything they might bring up in their presentation. Right. Very good. How would you like that to go? Court's questions first, or your response to issues that you saw in their briefs that you need?
Very good. I'd like to bring up the response if I may. Specifically, this goes to the argument that Mid-Kansas has acted in bad faith, fraud, and used their discretion. I'd like to advise the court, not advise necessarily, but they never give you the standard of what that is. How do you even find whether the eminent domain party acted in bad faith, common law acted? They never set forth the standard. I believe your best cases to hallmark that are going to be Concerned Citizens United Inc. versus Kansas Power and Light Company. The citation for that is 215 Can 218. The other case that I'd like to draw the court's attention to on that would be Shuck versus Rural Health Service Company, 286 Can 19 at 27 would be the specific site. That's a 2008 case. And I'll admit the reason they probably don't give you the standards is not set forth very well. I can't find a Kansas case where the Supreme Court has determined that somebody's acted in bad faith. They don't cite one either. The closest example you have is probably City of Wichita versus Meyer, but that's not a bad faith. They have separate issues, so I'm sure you've reviewed that analysis. But in the Concerned Citizens versus Kansas Power and Light Company and Shuck versus Rural Health Service, they point out that the presumption is in favor of the common norm for having acted reasonably and for not abusing its discretion. So the ball starts out with a presumption of no faith. Be the case now. Now, essentially, Mr. Stout, which everybody else incorporates by reference, is their argument. Argues that the lack of specificity in the petition is one example of how they've used it. Then they go to the description of track 13 as an abuse. And somehow argues that things that came up after the petition was drafted and filed within a subpart, such as the appraiser using a different acreage, is an example of bad faith on behalf of the applicant. Then the verified petition using the term due diligence and somehow ignoring his clients is bad faith. But there's no standard set forth for due diligence. I submit to the court that the title in the register of deeds is what conveys title to parties and people. If nothing else, if we review that, that's good enough. Talking to owners, there's no definition for due diligence. They're just asking you to say what we did for due diligence was not good enough without ever explaining to you what the Supreme Court has found as due diligence. Then there's this argument that we prepared the appraiser's report, which is perpetuated inadequacies instead of resolving it. Counsel that was involved in the case all agreed, signed off on the form for the appraiser's report. And lastly, there's an argument that we filed appeals and awards that did not justify the time and expense of the jury trial and used the uncertainties for our advantage. As far as I can glean, the uncertainties is the use of the word reason. Twice, Meyer and Klausmeyer argued that we don't get to use the word reasonable, say the word reasonable to a jury. Judge Mock denied that motion. The petition says what it says. We don't get to ignore that they have reasonable ingress. I'm familiar with your background as a prosecutor. Criminal law for hundreds of years has set forth the standard beyond a reasonable doubt. Yet they're urging you to ignore that as meaningless, despite that it's in the written petition, despite that juries comprehend and deal with the use of the word reasonable. Criminal law, court law, all of the time. The argument as to the petition is that it's vague, and that's somehow bad faith, but Shuck versus Rural Health Service is found, actually the Supreme Court found, filing a petition alone is not an example of that. There's this notion that we elected to create a legal fiction rather than dealing with it. I've already talked to you, already argued in front of you, the argument prior on track 13. This is how they drafted the deed. The deeds left a gap, it caused an overlap. The deed drafted our petition based on the language of the deeds. Then as far as the argument that we file these appeals as some punitive measure, we exercise our rights that are given to us under the statute. They're not left without a remedy either. They still could all go to a jury trial. I'm not Clarence Darrow, I'm not a top-notch trial lawyer on the United States Court. It's a winnable case. They could win it, they could get attorney's fees the normal way. Sunflower is the only party that has been trying to push these to a final trial. We've had a step multiple times, 2018, 2019. Filesmeyer and Meyer moved for a continuance and it was granted February 11, 2020. Andrews continued the case 3 times. Fired an attorney once to get a continuance. Argued for a continuance successfully while we had 30 people sitting here waiting to be in panel as jurors. We've been pushing for a resolution of this matter. Nobody could have predicted that we were going to have a global pandemic and a backlog of cases and not be able to go to a jury trial. I'm not faulting anybody for that. But it doesn't mean that we're laying away and profiting on it. The fact that we put you into the jury. I'd be remiss to not point out in summation, all the defendants have argued that you need to void this entire proceeding and start over. And despite the fact that none of them cite to a statute or a contract that requires attorney's fees, they just want you to assume that it's within your inherent authority. You void these, which is what they want. Void the entire petition, void the proceedings, start over. Oh, by the way, give us attorney's fees too without any statutory authority whatsoever. Anything. That's the only remedy they're asking. You have lesser remedies available. I'd submit if you feel that it's necessary to have the 4 tracks included in either the petitioner or the appraiser's report. The appraisers all knew the before tracks. Everybody was included on emails for the before tracks. It's obvious what they were. Simple amendment to the report of the appraisers to include the 4 tracks on a motion to amend would be sufficient to accomplish that goal. Nobody else would be any worse. With that, sit down. I assume you'll have questions.
Well, I do have questions about your brief. Counsel, the defendants want to respond to that point, which I incorporated in your presentation.
I think to save time, it seems to me that when the court wants, we give our collective presentation.
I concur, Your Honor.
Mr. Furness, and not necessarily firmly asserted in your brief, but you said it in court also, generally, that the court approved the petition. And some of that argument has been in the form of perhaps support that either Mid-Kansas did things appropriately or per statute, or implies that that procedural hurdle has passed. What do you believe the approval of the petition does, other than the court finding that the entity is as anticipated for these purposes, and that the taking is for lawful purposes? Those would be the findings, the statutory required findings of the court. But I understand some of your arguments, or believe some of your arguments go farther than that, and if so, what does that mean?
Your Honor, the court takes this up, and the statute literally uses the words, upon filing of such petition, the court, by order, shall fix the time when the same will be taken up. That is immediately after In 502, a petition shall include the authority for and the purpose of taking, a description for each lot, parcel, or tract of land, and the nature of the interest to be taken, and insofar as their interests are to be taken, the name of any owner, and all lien holders of record, and the name of any party in possession. Such petition shall be verified by applicant. When the court approves the petition, they took it up, they address all of those statutory facts. That would be our petition.
But what I'm referring to would be 26504. And what the court finds in the petition. Perhaps 502 doesn't necessarily anticipate or mandate the court reviewing intervening substitute. Perhaps 26502 only means that's the basis or starting point for rights to be affected, property to be taken. So is that wrong? And that's not wrong. What beyond 26504 you the court found and by finding established for the procedural posture of the case, underlying case.
I believe at that time they took it up with the parties involved at the time of the hearing. So they're just sitting there, they're certainly able to make objections. If you look at the concerned citizen versus Kansas City Power and Light case, a group of them filed an injunction because they thought they were taking too much profit. Taking it up at that time, you're determining if this is going to go forward and condemn rights.
I'll ask another way. Does the court approving the petition that also find expressly or implied that all steps leading up to the filing procedure and then findings by the court mean that Mid-Kansas did everything appropriately up to that point?
It means that they approved the petition. Perhaps that is limited to the topics of 504. Your Honor, I'm assuming you're going through my brief. Just, we're gonna irritate you if I ask what page you're on when we get this.
It will not. Hopefully will help. So I appreciate that. I'll be looking at page 10. The final paragraph started. Court faulted Mid-Kansas for failing to include named individuals, but rather merely publishing notice of certain real property in the tract and listing unknown tenants or persons in possession of property. What does that mean? The court faulted Mid-Kansas, faulted because it's now required briefing, or was it something else?
I believe it was probably in reference to tone during the prior hearing on a motion to void track 13 by class line. Yes.
What does the publication mean for these cases or the underlying action? You said before you gave notice to the world and things along those lines. But what does that mean and what have you accomplished by publication?
Your Honor, I'd just like to make note that the Eminent Domain Procedure Act specifically requires publication notice. And that's in addition to the mailing. You have to follow the publication. In addition to that, I believe if you look at our actual publication notice, it complies with the Kansas Judicial Council format, which doesn't mean that it strictly complies. It's got substantial. So if you look at the civil procedure rules for publication notice, those adopt substantial compliance with the publication notice in the format provided by the Kansas Judicial Council. You include the publication what's required under the statute. In addition, I'm arguing that it's in substantial compliance with another statute with a general service of profit by publication. All it is an attempt to give notice to as many people as possible what the property is, what you're trying to do.
And if your publication only had the easement description, not the original entire tract, what does that accomplish?
So if it has the easement descriptions, where this property is going to be, you should be on notice that a piece of property is being condemned within the line tract and one of the other. Those easement descriptions do include them.
If that publication mean what you believe, that notice and to those not particularly named or to the world, however you want to phrase that. That means that, but doesn't talk about ingress and egress. Was anything about ingress and egress accomplished through the publication?
The publication does not accomplish anything as far as what rights we have. That's strictly on the report of the appraisers and the petition itself. You're not trying to put the world on notice of all the contents of the petition. You're trying to put the world on notice that there's a petition out there. There is a duty, if you have notice through the publication, to go investigate.
Why have any descriptions in it? If that's the case, it seems to me you could shorten the publication, save the money, I suppose, for the number of words, and just merely said, we've filed this, there's a hearing, go look for it.
That's in part. We're not trying to save money on that issue or any others. It's just include the legal description, trying to give people in the Sumner County area the best notice you can. We're trying to follow the statute. We believe we complied with the statute. We believe we put people on notice. We don't believe that the publication notice gives us any more or less rights. Supreme Court is very clear. It comes from the Court of the Appraisers and
And if it does not give you more or less rights, is publication supposed to be held against a defendant anticipated by the statute possible defendant? Landowner, lien holder, party in possession, should be used against them, no other notice is given to them.
I need to know what you mean by using against.
Well, as you've argued before, given notice, and I think it was in the track 13 hearing that we had. I think that notice was perhaps a catch-all or summary or added to your argument that Klossmeyer had actual notice. And against constructive notice, and by the way, we published. And so if it didn't do anything more or less for the rights to take it, what did it accomplish? So as to be held against Klossmeyer in that just limited circumstance.
In that limited circumstance, it's another indication that we had notice of the proceedings going.
In that same hearing, we touched upon, I think I asked, or pointed out that tract 13 would be landlocked. And I asked how Kansas would access tract 13. And summarizing your response was that Kansas acquired reasonable ingress, egress, access rights over any of the property in the petition to access any of the easements in the petition. Was that your argument, sir? Is that the Kansas position?
Subject to reasonableness, yes.
If that's the case, why would not all landowners be named in all tracts for purposes of being present at that particular hearing for that tract to present evidence that perhaps Molitor's ground is the easiest way to access the easement and will be accessed the entire time, and then they'll just run the easement after that? Should that have happened?
I don't believe so, Your Honor. You're saying, why wouldn't we just put every landowner on notice of every tract and claim that everybody knows interest in every tract?
As an example, how would Mr. Molitor, I'll keep it in this place, how does Mr. Andrew show up to argue that Mid-Kansas is gonna access his ground, use his ground for access to the easements on, Florida strand? I understand this one touching, but that just for purposes of our argument.
I can't see any reasonable scenario where we use somebody else's ground that's not touching each other, not contiguous to access it.
But you took those rights
We took a right to go through their property.
to access any of the easements or the easements listed in the tracts.
To access any of the,
And where is that pled? Does that need to be separately pled, clarified? Can you make that out from the petition?
I think we made out from the petition. We have ingress and egress as long as it's reasonable into, through, over.
Be described properly.
Yep. Judge, let me ask you this, this is my contention, okay? Not all of these are gonna be contiguous pieces of ground, but more than that, again, most of our easements were acquired by an agreement, not condemnation.
What bearing does that have?
These aren't all gonna be contiguous tracts. Sometimes you're gonna have a condemnation tract right next to the easement that was acquired by agreement. You got easement rights over both the properties.
If the petitioner has the duty to define the limits, and that's not expressly stated in the petition, is that a limitation in the Mid-Kansas actually take access rights across any and all grounds listed or any and all easements listed?
Did you repeat the question?
Do you agree that it's not expressly said that Mid-Kansas has access rights across any ground listed or any easement listed?
I would agree, that doesn't explicitly state.
If it's not expressly or explicitly stated, is that a limitation?
No, I think you have to consider the petition to the maximum extent possible. And the defendants have thrown that same case in my face a lot of times.
And
You
how
have to construe the rights to the maximum extent possible.
do I do that? With keeping in mind the protection of landowners' rights, constitutional rights?
Keeping that in mind, we had the appraisers valued property, they were awarded awards from that. Appraisers read the petition, the amount was able to instruct the appraisers on it. They're considering it to the fullest extent possible. You know, that have to arrive at that.
Page 12, final paragraph prior to subsection C starting, read regardless if Kansas paid an amount of the award. The property taken, not based on the rights of the different interest holders. And what I had in my mind were parties in possession. Why are parties in possession even named in the statute?
Insofar as their interests are to be taken, they're required to name.
And
They have the right to come argue for a division of the fee under 2657.
they have a right to participate also.
If their interests are to be taken. Yes.
And talk about how their crops might be damaged for the access. For the good, and building on our previous topic, discuss how crops may not even be able to grow if there becomes a two track across one set of property to access all of the easements. You agree with that?
I agree to have a right to show up and argue about how their crops may be damaged.
And so I'm struggling with not based on the rights of different interest holders. Party in possession has, whatever it might be, listed in this area, has an interest in what's growing on the property, or the cattle that are grazing the grass.
Judge, I've got a short little, one of the factors is specifically a loss of proper use. Productivity from the property. Yeah, I acknowledge they have a right to argue. The value, however, is set by statute. What's the fair market value before? What's the value remaining thereafter? That is one award. Those factors can be considered as part of it, but it's one award. And then the division of that is what's considered and contemplated by 5-7.
But we'll take Klossmeyer as a party in possession for this example. Formed the entire northwest quarter. For purposes of my question, assume the easement is the entire northwest quarter. Klossmeyer would be short 160 acres plus wheat that he has an opportunity to farm and make income on. So the value of that ground to him is not stated anywhere. I agree that statute doesn't expressly say that. The Howard right's not implicated if that would happen.
We didn't take the property in fee. I mean, he still has the right to go farm that property, go harvest wheat, harvest whatever crop he has growing out there and use it.
Understood. What if your power line was the entire width of the section, ran the entire distance of the section? All crops could no longer be grown on that section.
That's not the case we have in front of him.
Understand? Or when, at no point, in fairness, at no point are the rights of the different interest holders in issue. You know, either the underlying administrative procedure or this court's authority and jurisdiction.
You repeat that, Your Honor, I'm sorry.
By your statement that I referred to, the rights of different interest holders are never a consideration as anticipated under the eminent domain procedure act.
Again, these are factors that can be considered. What that sentence refers to is there is one award, there is a specific formula for how that's done. Crop damages was raised to the appraisers. The appraiser's hearing can consider crop damages, possible crop damages, but the appraisers still come to one. This was discussed.
I might have a question too about crop damages later, but I'll keep going through your wording. Top of page 13. These were described within exhibit A, a meets and bounds description, easement, and a surveyor's map that includes the legal with the ingress and egress rights. Why would it be important to specifically describe the easement, meaning the meets and bounds description of the easement, and then it's totaled in both square footage and acreage for the easement, but not for the entire tract?
You mean the entire part of the surveyor's map?
The entire tract as anticipated in paragraph 6.
Yeah.
Why was that? Why was it not important to specifically or separately define that? Or even if the court agrees with your reading that the described property is in the attachments, certainly not total, similar to the easements description. Why would that not happen? Is that important? You see a distinction between those two?
You do actually see a distinction between those two. One of them is where the line's actually going, and one of them's just talking about ingress and egress to the lines and the equipment from the Kansas house within that specific lane of boundary.
And that means something less should suffice for the described property or description of ingress and egress where that can happen.
I don't understand what you mean. You want me to get into the intent behind the drafter?
No. Trying to understand why the different or explore why you believe the described property is in the exhibits.
Oh, that makes sense.
Why is it not separately defined? I think you decided there it could have been more exhaustively described, perhaps. But regardless, it's not total in square footage and not total in acreage, like the easement is.
Correct. Suppose it gives them flexibility, but again, I think you're asking me to get into the intent of the draft. It says what it said.
I agree. And your distinction didn't necessarily, you see a distinction, but it didn't necessarily go into what I was asking. If there's a distinction, why is there a distinction between the two?
Because without reading into the intent of the draft, there's a large difference between just coming and going to a piece of property versus we're putting poles, line, equipment, energized lines, 24/7, 365. Which right center paragraph 5, that's what happened. Ingress and egress is not exclusive. It's just, I don't know, it's a different thing. Your Honor, if I may go back to crop damages for a minute.
Yes,
I would like to draw the court's attention to paragraph 7 of the eminent domain petition, last sentence. Except as removed, cleared, trimmed, controlled under paragraph 6. Plaintiff shall reimburse defendant landowners for actual crop, livestock or surface damage on the easement or defendant landowners adjoining property caused by the land. So there is an argument that the petition did not extinguish the right of landowners and it's kind of claim crop damages for the ingress.
that would be one shot at that, is that correct?
No, I'm saying there's not. There's not. That would be a limitation on our right. I think under the courts and what the courts alluded to without actually saying it is, well, you've extinguished the right to ever come and argue for crop damages, but of the farm damage. But I think that paragraph 7, that second sentence allows an argument and then to come ask for crop damages, livestock, surface damages at a later date.
It says on the easement.
What do you mean on these? I'm talking about paragraph 7.
Yeah, I'm with you.
Okay.
Except it's cut, removed, cleared away, trimmed, and controlled under paragraph 6. Claimant shall reimburse dependent landowners for actual crop, livestock, or surface damage on the easement.
Right.
For the dependent landowners adjoining property caused by the claim.
Right.
Those two are different than the described property in paragraph 6. I mean, term wise.
I agree.
Paragraph 7,
Paragraph 7 contemplates plan handling the crop damages other than where you're cutting, removing, clearing away, trimming, controlled by machinery, otherwise any and all trees, brush, shrubbery, or soil, whether on the said easement or the activity that may interfere with the safe operation and maintenance of the power line. So except as where the crops damaged based on that language, they still have a right to come claim crop damages for under our ingress and egress or moving on.
and that would be their duty to observe, investigate, and bring to your attention.
You're gonna make a claim for crop damages, yeah.
And you believe that's on the easements in 4 and 5.
No, I believe that's as long as we're not exercising our rights to trim and cut away something that interferes with the operation of our easement under paragraph 6.
And it says easement, that's talking about the same property described in paragraphs 4 and 5. Is that correct?
5 and 6, yeah. 4, 5, and 6. 5 and 9.
Your- The easement is described in total under.
Correct.
We have questions over what the described property in paragraph 6 is. So you believe it's the entire tract, and that entire tract is somewhat described in the description of the easement. Is that correct?
Okay, so we've used a couple of things. I think the described properties is any properties described in exhibit A, which includes the surveyor's map and the easement description. Paragraph 5 specifically applies to the meets and bounds of the description.
And so what's the end of that? What's the extent of that? What was described? You said anything described in the exhibits. What was described in the exhibits?
Meets and bounds legal description for the actual easement, then the surveyor's map describes the larger property that you have reasonable interest in.
And for purposes of reasonable ingress and egress, we will go to. Today. What is the description of the described property?
Southwest quarter of section 34, township 33 south, range 30 west.
And that is relying on page 202. Westwood Professional Services.
Correct. Surveyor's map.
And so the bold heading would be the easement description in parentheses, easement area. Start that.
No, Your Honor.
Okay.
One above it. Exhibit A. That's what I'm talking about. That's where I'm getting southwest quarter, section 34, township 33 south, range 3.
So the dotted or striped off, I suppose, and sitting in the middle of the property.
Yes, sorry, I was trying to piece together,
Sat at a 45-degree angle, I suppose, from southwest to northeast. Right.
and just completing the argument that I made in brief. Sure. The easement property is actually shown the dead picture too. So the easement properties are all part of the larger properties shown.
I should use a better example, but we'll say with it. So that's at southwest quarter, section 34, township 33 south, range 3 west, is that right?
Correct.
How many acres is that?
Sounds like it'd be about 160.
And who knew that? And then underlying administrative procedure
As far as
for the purposes of determining value, and the appraisers report, I guess I'm just going to the appraisers know
did they know what that we got a reason?
how many acres were issued. Or just the description.
I believe so. You have to look at the emails wherein we emailed the appraisers the entire packets where everybody approved the 4 tracks, except for Andrew. That looks like the property that we have, that we own, the entire property before the taking. That included acreage.
In the report of the appraisers that talk about the emails and knowledge gleaned from getting outside of the petition and doing it.
No, it does not.
So other than your statement that emails exist and they reviewed them in light of somehow the court determined that
How did the court determine the acreage?
also the court determined I suppose the acreage, but then what the appraiser provide on for purposes of ingress and egress.
The acreage could have been submitted by the parties and agreed to.
That's their duty for pass that on.
You'd ask how was the court supposed to know it? So and that's how I would estimate the court would have done the property before and after. We largely agree.
Kansas could have too also, right?
Kansas could have put it on that.
Parties could have this.
As far as how the court knows, you can't look beyond those 2 things. As far as the rights.
So better example would be Bachmeyer, example, track 8, for instance. It has northwest quarter, section 31, township 34, south range 3 west. But that's the same description for purposes of paragraph 6, reasonable ingress and egress. And you describe the property.
Yes.
But
Aside from the fact that Mile land is the west east.
and that would be where I was going with it. What all can this be read into that?
What can all be read into that? Oh, sorry, you said you're on Cloudmire? Oh,
Tracks here, track 8.
So his specific tracks are shown in the bold line. The bold line and then like, right. I can't take something he doesn't know. He couldn't convey me access over the needs.
Sure. And for purposes of evaluation on track 8, now we're dealing with something short of order and a common knowledge of 160 acres. Not for purposes of Qualifying hearing at the administrative level appraisers.
And
So how does anybody know what the appraisers considered for purposes of paragraph 6, Mr. Qualifying's hearing?
in the little square where it goes starts with Mid-Kansas Electric Company LLC, it does have the West 86 of the northwest quarter of section 31, township 34 south, range 3 west, principal meridian, Sumner County, Kansas. That's what his deed gave him the ownership interest of. That's what he showed up to all the appraisers, the 2 appraisers hearings for. Landowners are allowed to make arguments at the appraisers hearing for their value. This shows that he owns that west 86 acres. That's what the deed shows.
Now, what are we looking at? Are we looking at the 45-degree angle wording? Or now are we looking at the bottom of the page, for purposes of paragraph 6, Qualifying hearing?
I'm looking at the bottom of the page, what he had.
Now usually this is defined twice. To describe property.
No, I believe it applies to what the actual owner owns. So the map tells you we're dealing with the northwest quarter of section 31, 34 south, township 34 south, range 3 west. It outlines the property that he owns based on the deed, then tells you what the ownership interest is in that square. That's what we're looking at for track date. He's there, he's participating, he's allowed to have input on who the appraisers are, he's allowed to speak. You have to go off with somebody actually done.
I'm trying to determine how easy or hard it was for the appraisers to determine that.
I don't know how easy or hard it was for him to determine that. We don't have a transcript of what it is. I think it's
Who did that before the appraisers?
I believe it was drafted by my partner Taylor Calcara and then sent to other attorneys for approval and then we filed it.
And what? Did the, or any duties implied by the process on the defendants and the counsel for purposes of clarifying that?
Whereas under chapter 26,
But I'm not sure where the defendants might have a duty to come forward with pertinent information or arguments for or against, or make sure that the entity does things the way the entity wants to accomplish their intent, so. Or the attorney's signatures aren't on the report.
they aren't on the report, they are not.
Is that correct?
No, they're not.
And so even if what you say is true, and I have no reason to doubt it, but what does that mean? They proved it that the appraisers did their job. They proved it that the appraisers did their job, and it's sufficiently discussed and broken down. The attorney's signatures indicate that they approve that the appraisers only considered the eminent domain petition in their views. What does the defendant's attorneys acquiesce, I suppose, to the document for approval of whatever? What does that mean?
Yeah, under Rule 170, Kansas Supreme Court Rule 170, if somebody's directed to draft it, typically if your signature is attached and that you reviewed it and you okayed it as. If you have objections, you have an opportunity to raise those objections.
Page 23, you're discussing possible remedies, second paragraph. Any parties in possession who were in possession of individual property can simply intervene, participate in a jury trial, and split the resulting reward of the defendants under the procedure of KSA 17CV117. I understand intervening in a case might mean something different than them coming forward, being known, intervening in taking purposes. Is there a limit to what you meant by intervening?
I quite literally meant file a motion to intervene and be allowed to participate as a part of it.
How do they, that's just talking about people that know about these cases that are still going on,
Just these two,
not after, there's nothing that Kansas needs to do to invite them to perhaps.
believe so.
That the motion to void the taking of track 13, I believe Mr. Kaplan, it wasn't necessarily Crawford, but Mr. Kaplan showed from council table a map that had Mid-Kansas designation in the corner, but showed track 13, I'm sorry, that quarter, track 8, 10, and 13 one, to be consistent with what the Register of Deeds had, being two owners. Why was that map used by Mid-Kansas?
Do not know, Your Honor.
And does that have any weight, or does that affect anything we're doing today?
I didn't brief that topic.
And that's perhaps fair. Do you agree that one of the possible remedies or fixes that the court can make is that simply the easement is the described property, but court notes, I didn't see anybody argue that in briefs, but is that one possible remedy, just a limit, given the ingress and egress to the easement?
You're talking the actual legal needs of house description.
Talking 4, 5, 6, and 7 are the exact same described property. And perhaps just the easement as it's the most described, best described property.
Well, I thought you were specifically asking for the remedial authority, but certain,
To fix the issues.
right. So what you're proposing to make an analogy, I think we could all be really familiar with. Eminent domain is not my sole practice, like it might be some others. Let's say we got a contract dispute. My interpretation is this argument, somebody else's interpretation is this argument. You always have the right to decide what a written document means. That's just your ruling, right? So this would just be the same. You're saying, you know, Mid-Kansas, appreciate you doing property description and what you thought the intent was when you, or not, or what your interpretation of that petition is. I disagree. That's just you ruling with us with what the scope of the easement is. That's certainly in your.
And if the court shows that option and the landowner continues to have knowledge of Mid-Kansas coming across 360 degrees of property to get to the easement construction post, statute of limitations aside, that would be another question about whether they knew what they had rights to, not have rights to. whether damages exposure or liability exposure, I'm in Kansas for that.
Sure. You're exposed to the trespass action. Also not referenced in any of the briefs, and that's not critical, that's more along the lines of me saying, maybe I'm way off base, but Mr. Turns, you acknowledge to two other cases have were consolidated and gone through trial. So I'm not trying to get into that case necessarily, except that. You want to give
2017 CV120 and 2017 CV121, that'd be Burrish and Molitor.
correct.
And the award was certainly larger, I'm sorry, the appraisals award certainly larger than the jury award.
That's correct.
Why do you think that was?
Why do I think what?
Yes. And can the court take that into account to at least affirm its concerns for this case? But maybe even farther as evidence that the petition, what the appraisers did, could have drastically different interpretation.
I don't think it's proper to consider that as evidence. No, I think it's just for one jury to decide. If you're looking for details from that, I mean, certainly an employee to ask Judge Mock and don't just take my word for it. But the argument to him was, I don't get to come in and talk about our intended use. That motion to eliminate held up for Mr. Peck and his clients. There was no mention of how we're going to access it. There's just, hey, you got a feasible ingress and egress over the larger piece of property shown in the map. Here's the specific needs and bounds description where they go to put the equipment that's related to this paragraph. And honestly, there wasn't a whole lot of discussion about that. Mr. Peck brought it up, and then it was just, here's our expert, here's their expert. Here's what my client values it at. And it was just a discussion about them. Kind of what you should back in the case in this moment. Have for those two argue the values, and then jury has to find somewhere within the range of values. That's what the case left out.
Kind of answer that why it's not being critical also. You were explaining it, but it's something I can't consider to the extent that your references should be not considered also, or with your explanation, I can think about it, consider it, apply it.
Well, I thought you meant specifically as evidence that the jury could consider a lot of discrepancies. Again,
For purposes of determining whether the petition is statutorily sufficient, deficient. And I look at the difference in appraiser awards and jury awards in the CV120 and the CV100.
I don't know what bearing that would really have on strictly the rights acquired through the petition. Really hard to make that determination just simply based on the jury awards, because that ignores, what moved the jury. The arguments of counsel, the cross-examination of an expert witness. Was it something else? How come they arrived at that award?
Do you remember, were the jurors given the emails referenced that were given to the appraisers?
No, they were not.
that totaled the amount of acreage for purposes of ingress and egress?
No, they were not. They were showing pictures of what was in the email by council because we agreed on what the report track was. So it's submitted, we just agreed, here's the four property. And now I'm trying to remember 4 years ago. I made those two might have been unique, but the before properties are actually what is listed in the petition as well for the larger surveyor's map. For example, the before property, I believe, was the northwest quarter of section 35, 34, 4 in Sumner County, 4 Burrish. So Martin Peck exactly argued that they have reasonable ingress and egress for the entire property of the before property.
And again, you were there, none of us were that I know about.
Actually, Mr. Paulsgraf watched for a day, and Mr. Amber watched every day, and actually testified.
There was some discussion or instruction of what paragraphs 4 and 5 might mean, and that how that's different than paragraph 6. For property purposes, for what to be considered size wise.
Oh, yes.
For something else to come up, those were the questions that I had after reading your brief.
Thank you, Your Honor.
Mr. Turner. Council 20 afternoon, might be an appropriate spot to take a break, for sustenance, again, the council will get their thoughts together on what they respond to outside what they had prepared for. Any problem with that, Mr. Turner?
No, Your Honor.
40 minutes or an hour or 10?
40 is fine with me.
Mr. Paulsgraf?
That's fine, Your Honor.
Mr. Matt?
Yes, Your Honor.
Steph?
Agreed, Your Honor.
That clock's got 20 after, I've got about 16 after, we'll be off record in recess, we will reconvene 1 p.m. back here. Thank you.
Thank you, Your Honor.
Thank you.
All right.
I should have said that one. We'll let Ms. Bannister do that. Thank you.
No, you should have mentioned going to longer than 40 minutes.
No, it's all good. I think we all want to, Friday would like to be done, but it's just like I said, like Kansas, it's a little limited.
Aye.
Thank you, everyone, that's it.
We have to use Friday, closer to the.
Good. All right, and now, good afternoon, everyone. This will be the afternoon session of Sumner County District Court. We're back on the record. These are cases 2017 CV118, 2017 CV117, 2000 CV119. Mr. Andrew, the 118, Clark, 117, Meyer Revocable Family Trust, Crossmeyer, 119. Appearances remain the same. We completed Mr. Ernest's presentation this morning, that being in support of the plaintiff, Mid-Kansas Electric, and their briefing. We're now ready for Mr. Paul's draft presentation. And Mr. Ernest, if you thought of something you needed to include, we'll have that opportunity when we close for more response. Mr. Paul's
Thank you, Your Honor. I know the court's read the brief, and I'm going to try to keep this relatively brief and not simply restate what's already been presented to the court. I'm going to have some fairly harsh things to say, not surprisingly, about Sunflower that are well deserved. Having said that, I want to caveat that in many of those instances, whether obviously a petition drafting stage or responses to discovery request, no counsel in this room participated in that, specifically opposing this. So he inherited this file such as it is. As it relates, I think it's important to begin with what the Forex believer is not at issue at this point in time. Specifically beginning with what remedies this court can do or what restrictions exist upon this court. This court clearly has subject matter jurisdiction and the inherent authority to remand this case for a new appraisal and other amendments, including the petition. Sunflower admittedly doesn't want that, but Sunflower in its briefing at page 22 states, this court could also remand the matter for a new panel of appraisers and require amendment to the petition for eminent domain curing the rescue. So that analysis corresponds to the City of Wichita versus Meyer 262 Keenan 540. The second main category was part of the issues that the court wanted us to brief for today is what to do about the funds that have been paid, and then as a ancillary to that issue, what to do about interest accrual. And I believe that's answered, Your Honor, and is not disputed to the extent that Mid-Kansas in its brief at pages 23 and 25 to 26 admits that KSA 26507 requires the payment that had been made to vest title. And as a result, the landowners are in fact, even upon remand, entitled to keep the funds and have those credited against any future award herein. And again, that obviates then any discussion or concerns or worries that I think the court expressed in the hearing we had when we were being directed on what was to be briefed. I think that should take care of that issue. So again, I appreciate Sunflower vehemently argues that it doesn't want the court to do those things, but it acknowledges in its briefing that the court hearing in fact has that power. Now turning to kind of the overarching, I think is the term I used in the brief, view the court should have of this file. Mr. Turner started out with a bad faith analysis, and while I appreciate and can challenge the showing by the landowners of bad faith, while I appreciate in some circumstances bad faith may be relevant herein, The truth of the matter is that turns the world on its head. As cited in the briefing in the Water District number 1 and Prairie Center development case, what did the court say? It said, we urge condemning authorities to be scrupulously fair in the exercise of eminent domain. Always cognizant of the responsibility that comes with a power so great. Justice Eagle, in a concurring opinion, Your Honor, was even more specific. He stated, I am mindful that in the past, when considering the potential for abusive practices in eminent domain proceedings, we have noted that it's difficult to conceive of a policy of government afflicted with greater potentials for abuse of a private citizen. And as cited by defendant Andrew in their briefing at page 3, eminent domain powers must be exercised in strict accordance with the essential elements in order to protect the constitutional rights of the citizens to own and possess property against the unlawful perversion of such rights. And that's the National Compressed Steel site that's in their briefing. As a result, while most certainly the condemner has significant rights, unimpeded rights to some extent, if it follows the law under 26502 in a correct petition that no one can challenge, the law doesn't give a condemner unfettered rights. And in fact, it imposes upon that condemner that duty not to act, in fact, just not bad faith, but the condemner to act in good faith. Now let's look at some of the facts here, and again, I'm going to keep you short. I know the court is painfully well versed, but beginning with the petition, and you had a number of questions about that, so I'm going to keep that short, but there is no question that the petition filed herein does not comply with 26502. It simply doesn't. And there's acknowledgement it doesn't. It's just we're going to clean that up with ancillary documents like emails and those types. That statute has what language in it? It has shall language. And as noted in the briefing, shall language in statutory construction means something. And Mid-Kansas did not in any way, shape, or form comply with that shall language as it relates to adequate description of the property, and more importantly, what doesn't comply with the statute, the ultimate report of commissioners, because the report of commissioners, the appraiser, relies on what? That underlying petition. So every defect that was with that underlying petition flows through to the report of appraisers. But what's as or even more egregious is this intentional, absolutely intentional manner of drafting by Mid-Kansas to define its access easement by using the word reason. And that in part has set us on this 5-year path of ambiguity that permeates the entire file. It was a purposeful intent by Sunflower to do what? To minimize the monetary reward to occur in this table. What would have been hard? As we look at the Sunflower definition now, or their interpretation of the definition, which we'll go through in a moment, what would have been so hard about saying, using the word unlimited instead of reasonable? What would have been hard about saying unlimited access? Because that's in fact the argument they make today. It is in fact unlimited. And what's happened, and again, there isn't a council in this room that participated, but it's been a 5-year show here that started with the original pleadings to be able for the condemned to define any way it wants at its convenience what this ingress and egress easement means. And the best example of that is in 2018, we were in what? We were in the written discovery phase. So Lorix through my office sent requests for admission. And one of those requests for admission, which is attached to our later summary judgment, as exhibit 4, was a real simple request for admission scheme. Request 4. Admit that pursuant to that language contained in plaintiff's petition above cited, plaintiff can access the defendant's tract involved herein at any location plaintiff in his sole discretion determines, so long as adjacent to the plaintiff's utility line. We even put the word adjacent. Denied. They denied that they even have that right. That together with questioning that occurred of our expert witness, Mr. Stewart, in deposition, that made it abundantly clear what was happening here was that Sunflower was trying to minimize the scope of its stake. That triggered then the motion for dismissal. But contrast that tonight that happened in 2018 with the briefing that Sunflower had before the court today. At page 19 of the Sunflower brief, it defines its rights as the rights in paragraph 6 are associated with the largest property described in Exhibit A, which is found in each surveyor's map. For eminent domain matters, the condemnation is presumed to use all of the rights in the condemned area over the entire property. Consistent with that legal principle, the surveyor's maps contain the largest legal description that the reasonable access for ingress and egress rights encompass. They go on to say that combining the language with the common sense construction of the petition for eminent domain, and this is page 1. It is obvious that Mid-Kansas has the right to enter onto one side of the tract at the line to traverse the transmission line easement corridor to another property of reason. This is a logical and common sense construction of the petition for eminent domain. And this is just one example of many in the briefing where in 2018 couldn't even get an admission that they could come onto us from any adjacent tract. And now this easement's so broad, they get to come on wherever they want, however they want, from any direction. And I stood in 2018 in front of Judge Mott and said that the word reasonable was inherently ambiguous. Because, and the example I gave was if 30,000 customers are out of power in Wichita, Kansas, and the road is closed and they tear the heck out of our property because they have to come from here, there, and yonder, how are we ever come into court and get relief? How are we going to say that that was unreasonable? It is a subjective, undefinable measure, and it has screwed up this proceeding in addition to the petition description of it. It has screwed up this proceeding from day one, and we've complained about it. And there's no way that can be fixed. And again, whose responsibility is this? How did this happen? We didn't draft it. The courts weren't even represented at the administrative stage. This all falls on the doorstep of something. And it's not our doing. The next thing I wanted to address with the board is that, yes, we're all aware as a part of this that the law is clear. You can't use parole evidence to later define your reason. There's no dispute of that. But that begs the issue. That's not the problem herein, although they tried to do it early on. The problem herein is out of this sea of ambiguity, we've heard definition after definition after definition as to what the petition encompassed. First of all this questioning this morning, why is all that questioning occurring? Because of these inherent ambiguities. Then we throw on top of that this inability for anybody to describe what reasonable means. And we're in this hopeless dilemma. And then what Mid-Kansas says is it doesn't matter how poorly we draft it, it doesn't matter that we try to take advantage of that ambiguity. And I said poorly, it wasn't poorly, it was intentional. We try to take advantage to our benefit of that inherently ambiguous term. Well, Judge, we're safe because under Landau, we can come in and we can amend that petition at this level, at this late date, and make it work. And that won't work because absent the court finding the statute to be unconstitutional, that we're going to talk about in a moment. The realities here are our only hope under the current statute for recovery of attorney's fees is what? That a jury setting hearing and understand what those appraisers consider. Now, I think it goes to the point that the court was asking Mr. Furnace this morning is, what did those jurors consider? And it's why we, according to the court's comments, that one of the reasons we're here today is because how do you instruct the jury fairly? So it's an apples to apples analysis of what the appraisers considered in the C of M. And we would respectfully submit that there is no way to do that. We have no dog in the fight, my client's lawyers on the draft code issue. And we'll certainly admit that we defer entirely to Mr. Kaplan and Mr. Stout on that issue. Having said that, the whole handling of that track 13 issue is further indicia of the entire manner in which Sunflower has treated this entire process. And again, it doesn't affect us directly, but the court doesn't have to consider it about it. It shows their cavalier attitude that they can do whatever it is. So there was a comment by Mr. Turnus about, well, we have to show, in statute state, you have to show basically that if a petition is insufficient, that your rights are harmed. Well, how have our rights been harmed here in it? Well, my clients have incurred 5.5 years of attorney's fees fighting this language that now, if the court does what we ask, is going to have to be all remanded back to square one. And there's no question that their rights have been substantially harmed because the attorney's fees are rapidly consuming what they were awarded. In our situation, as bad as it is, with $57,000 award, is not nearly as bad as the Meyer-Klossmeyer situation. So as I say in the briefing, faced with these facts, keeping in mind that we filed the motion to dismiss in 18, keeping in mind the statute said that that wasn't something we could appeal on an interlocutory basis. Absent us simply saying to mid-Kansas, how much of the $57,000 do you want back? And us writing a check to mid-Kansas under these facts, how could we possibly protect our rights? And the truth of the matter is that we've all been put in this unhappy posture that's having tremendous adverse monetary consequences for our clients through absolutely no fault of ours. And the question I think for the court is all of that conduct in keeping with where I started this argument on what the law understands the condemner obligation to be. It's not a situation that we have to prove up bad faith in most instances. It's a situation where they're supposed to act in good faith. And the court has to ask itself, is this a pattern of behavior that matches that duty? Do those words of the Kansas Supreme Court have any meaning in truth and fact, or are they just words? Because that standard clearly hasn't been met in this file. Now, the attorney's fees issue, we've been very candid with the court that it is no small matter to ask the district court to find the statute and the Constitution. In my almost 39 year career, I've done it once before, and I don't think it was frivolous. I lost on 43 in 1992. But the point is, in my life, professional life, I've asked the court now. But the reality here is, when you look at the numbers, you look at the conduct, and if the court remands the file as we believe it must, back to square one, how in fact have our constitutional rights not been impeded? Counsel for Sunflower said, well, they don't cite a statute that supports this fee recovery. No, we cite something better. We cite 12.4 of the Kansas Constitution. And the reality here is that the court can in fact, as cited in the briefing, find that for these, under these facts, that 26.509 is unconstitutional. It can make that finding. And that statute is severable by law from the other statute. Simply put, we're not going to collapse the condemnation statutes in Kansas if in fact the court agrees with the forward position that the statute as applied again to these unique facts is in fact unconstitutional. I cite in the briefing, you've read it, I won't recite it herein. We're aware of case precedents on stare decisis, but we're also aware of the case precedents that states that when a law is clearly wrong and has been wrongfully decided before, that in fact the court is not bound by the doctrine of stare decisis. And in the dissent that I cite from Justice Johnson towards the end of our brief, it talks about the fact that property rights, and that was that natural gas thing. It talks about that property rights cannot be taken away or should not be taken away from citizens by virtue of statute. And I would respectfully argue to the court that that is exactly what's happened herein, because as the current sets have applied to these facts, there's no argument that 26.509 requires that we in fact get a jury award that's $1 more. And currently that's not possible. And the reality is that this could, let's again get out of the ivory towers and just be realistic. If the court orders remand as we request, we go back in front of the new set of appraisers. Those appraisers come back with an award that we're satisfied with, and Sunflower makes the strategic decision they're going to live with that, and the case is resolved. It's over. How do we ever get our attorney's fees unless the court finds, as we promote, that 26.509 under these unique facts is in fact an we are without a limit. And surely, and if in fact that is the law, Your Honor, the law is broken. And it needs to be corrected. Because again, if we're realistic, what were my client's options? We don't have to be theoretical. They didn't ask for this condemnation proceeding. We all get that's the law that allows it. They didn't ask for the appeal. We all get there's a right to appeal. But where the train comes off the tracks on this file, Your Honor, is my clients had nothing to do with this drafting of the petition and the report of the president. My clients had nothing to do with the fact that it was drafted in the fashion that it was. And my clients, what more were they to do other than to file their motion to dismiss that they did years ago? And so if we don't recover our attorney's fees, contrary to 12.4 in Kansas Constitution, there is in fact a taking without compensation. Now, if the court remands, there are some nuances that we brief, and I'll keep this brief, but there are some nuances of dominoes that fall from that. One of those, and again, we think interest is not in play, and we don't have to get into the COVID issues as to what that does or doesn't mean on interest if we keep our rules. But some of the nuances that need to be dealt with by the court is if there is a remand for a new appraisal, what value before and after valuation numbers are we using? Are the appraisers to be instructed to try to go back and recreate what they think
the taking was worth in 2017? Or are they to use current numbers? It's our preference and it's self-serving because land values have gone up, you know, in the first decades. But it's a fair penalty for Sunflower to have to pay. We're in this mess today. Why? Because of ambiguity at the administrative level. Rather than have more ambiguity at the administrative level by creating and trying to create fictitious 2017 numbers. 2023 numbers on it. Because they are current numbers that are supportable based upon current conditions. Is it possible? Can we all go out and hire experts to recreate 2007? Yeah, we can. But you're going to be asking what usually are lay, semi-lay appraisers that happen and have some experience in those fields to go back in time and try to dream up 2007. So while it's not the most important issue in the case, or yield on it, if the court thinks that's overreaching, it would be our preference that 2023 numbers be used because again, we don't set up another dispute over how they arrived at numbers by trying to reach back 5 or 6 years ago. So our requested remedies, and we believe the court clearly has authority, is the court will remand this matter to a new set of commission. The petition should in fact be corrected so that we do not have this ambiguity again. The language, I think, but I don't care what term is used, but the language unlimited to me is instead of reasonable, is consistent with what I'm reading in the brief as to access. The owners keep the money that's been awarded that can be credited against any future growth. There is not an issue as to interest. The court awards attorney's fees that will have to be set for future hearing because the court will have to determine whether those fees are reasonable. Based upon the court finding that under these unique facts, 26,509 is unconstitutional. And again, if the court wants to do something different, obviously, it's just not a huge deal to us. We would strongly recommend that the appraisers use current valuation, not 2007. Thank you.
Thank you. Ms. Bograf, your thoughts on my questions to Mr. Ernest about the proceedings in CV120 and 121 up to and even through comparing the jury award and the appraiser's award, whether that any of that is appropriate to be discussed, considered by the court, applied by the court. Any thoughts on that?
Well, in my outline, Your Honor, I had it prepared, which I didn't touch upon, that the court should not consider those files. I don't think when I outlined it last night, I said it shouldn't. That even if I think it definitely has to be benefit us, I think no, yes, no, it should.
What about, I'll try to lighten that up a little bit. What about, or even the court's concern about how to instruct the jury, but not to support if the court finds the petition deficient, not for that purpose.
I think the ultimate jury award amounts are off limits because there's too many amounts. I think it's certainly fair for the court to consider all the logistical issues that occurred in trying to instruct jury in that trial as a result of the way documents lay some part of it.
And the other potential remedy of the court simply construing all references about size limited to the easement.
And that won't work because again, let's forget about this, let's play like this was a normal case. Take the constitutionality attorney's fees issue away for a moment. In a normal appeal, the landowner's biggest protection is what, that if the condemning party appeals, and we get $1 more, we get our fees. What I argued in 2018 in the briefing stays true today, and I filed a motion to dismiss. In order for the lawyers to have their full rights under 26509, we have to have certain that jury sitting in that box is considering the same scope of taking that the original commission. And that's the bottomless pit for him that I've argued for years. Can't be done. Because we don't know, because of, again, screwed up is not a very legal term. But because of how screwed up the administrative process was due to Sunflower's grant, there isn't any way to get the file into a posture where it's an apples to apples comparison. And if it's not an apples to apples comparison, and that's again, to get the constitutionality fee that we set here as of today, whatever, how are we ever to get a fair shot from that jury over there on an apples to apples comparison when we have to get $1 more? And again, Your Honor, I think, and not to make a hard case simple, but if that's not the key issue, it's got to be in the top 2 or 3. And I know I argued it hard when we filed that summary judgment motion, and I think it was heard in January, we filed in December of 18, was this very point. You're eviscerating your being Sunflower. You're eviscerating these property owners' remedy to try to get themselves whole, even if the condemner does it. Because I got to stand in front of the jury and have a fair shot. And so, yes, I have to answer your question succinctly. If the court looks at the instructions and how this issue was handled in front of the prior jury, I'm fine with that because I think it shows this utter Pandora's bottomless pit that can't be solved. I'll agree with Travis, right? I think I agree with Travis that it's improper because of all the variables to look at all of them. But the court can most certainly say, well, because what's not in front of this court is to say, okay, you fix your petition, you guys go, well, I'm not going to remand, you go forward in front of the jury, and that's hopeless with prejudice. For that reason. And again, Your Honor, this is something we have vehemently complained about over and over again through this file.
Is there a reading along those lines? I understand your point. Is there a reading of the petition that is, in your opinion, the least prejudicial to your clients? Or is it simply that can't be ascertained because of the difference in the panel and jury?
It can't be ascertained simply. It's proven it can't be ascertained by all these questions. It's proven by all of these different positions in this brief. There is no way to determine what a panel decided on a hopelessly, inherently vague and ambiguous position. And the moment that happened, there was no fix. And again, it's not rocket science. If the word unlimited was there, versus reasonable, it wouldn't solve the other petition drafting problem for Tyler, but on the second issue, the scope of the ingress egress. There would be an argument here on that, but that's not what it said. And the fact, and we can all talk all day long about the case law says you never can't change the meaning, can't get the parole evidence. That's all swell, and that is the law. But it is absolutely prima facie proof. When the condemner believes it has license to define in different briefing, different ways, what was taken. That where we start was inherently ambiguous and everything that flows.
Regarding the request to believe 26/509 is unconstitutional. I didn't expressly hear it, though. You believe, it probably goes with your thinking rationale you expressed. Is the statute can be found unconstitutional, considering that it only allows for the condemnor to initiate the appeal where attorney's fees is even on the table? Under that statute.
Yes, I don't understand.
So that statute you cite, 26/509,
Right.
it says whenever the plaintiff condemnor shall appeal the award of the court. It does not allow defendant landowners to appeal and seek the same, if the same result happened, but they initiated the appeal, the attorney's fees are not authorized under that statute.
Yeah, we're not, I'm not asking that, but other council may differ with me. The court's not asking about reaching for a broader finding of unconstitutionality than this. I don't think it's possible. We're simply saying that under these unique facts, wherein the appeal went against us, the statute allows for the dollar more, but yet we're in this position that we should get.
And
I guess I didn't answer. I don't think we know these facts and who the appealing party is. I don't know that I care to flip that or go down that path. I simply know that under these facts, it's unconstitutional because we were saddled with this appeal. We had no say so at all in what brings us here today. And because we had no say so in the drafting, in the original appeal, surely there has to be a remedy under the Kansas Constitution, because if there's not, it is a taking without compensation. The fees are swallowing up these awards. And I'm sincere, I'm not embellishing, I'm sincere. And it's a rhetorical question. I can't ask a question for it, it's in the brief. Anyone in this room, what were the Clorics, the Fossmeyers, the Myers, and the Andrews to do under these facts? We don't have to change a single fact. What are we to do under these facts, other than say, Sunflower, tell us the amount of the check that we need to write you, and we're going to write that check to that. What were our options? And there were none. And that can't be. Sometimes the law is unfair, but that cannot possibly be constitutional.
But I somewhat see you, I would see you changing position if you agreed with my question about how the statute reads. That being the plaintiff condemned or initiated the appeal, because you're saying it's a one-sided process, perhaps. And so, if only plaintiff condemned or can initiate the appeal, that could give incentive for them to make sure the appraiser's award is higher than perhaps one might expect. So that the hurdle is higher in the appeal in the jury. And as applied here, perhaps it's just surrounding the emails that we talked. And the appraiser is having more knowledge, more ways to look at, more calculation, more specifics about what was taken than what a jury might get to hear. And if that's still separate from what you're saying, please define that. But if that somewhat streamlines or merges with what you're saying, please confirm that.
I concur with the court's position. It is inherently unfair the way the statute is drafted. It is specifically, I say unfair, it's unconstitutional. It is specifically unconstitutional under these facts.
Have you had an opportunity to look at either other states or how the federal system works as to when their attorney's fees might be triggered? I have, but not to a full extent. But the ones I have seen seem to indicate a lower burden. But if there's anything to say about that, please do it. I'm just.
I got with the advantage that you all have of electronic research. I got on early on before I wrote it. And it was more than a 10th circuit, but I kind of visited about 2 states. That was close to Kansas, so 8 to 10 states. And I tried to find a fact pattern. I was a little more specific. I tried to find a fact pattern rather than try to match up with their statutes when Orlando and ours. And I couldn't find the fact pattern that mirrored this one where the court had a similar statute and the condemner had engaged in what we say was improper behavior, unconstitutional. I just didn't know. I didn't look.
As to the nuances you discussed, if remanded to appraisers, specifically back date evaluations then or current, that implicates other statutes that, I mean, go to 2023. That's one of the reasons I suppose why it's in the Supreme Court rule, and one of the reasons I specifically included it. I wanted to know the date of take. Immediately before, immediately after. How does that jump to 2023? When construction happened, 2018, I assume.
Yeah, and I'm an officer for I gotta be candid with this court of every argument I'm making, and I would make it trying to have the court direct it to my preview, even when I make that argument, because I do believe in my heart it takes away ambiguity, because that's what brought us in the first place. But that's the thinnest ice we're on. And if the court believes, simply stated that if the court were to use 2023, and that's going to throw, for the reasons you said, these other statutes in play, I don't think they've got enough problems. So if the court believes after review that to do what we ask on the 2023 is going to cause issues, conflict with the other statute because of the data taken, and we'll deal on that issue. We've got enough problems, so I don't want to get to it.
Well, how do we capture what happened in 2017? Was that by a separate hearing and all 3 appraisers testified?
I'm asking from you.
I understand.
Yeah. I don't care.
They had the comps, they had the vision and viewing.
I would argue vehemently with the court, so you told me to sit down if the court were inclined to have the 2017 appraisers have anything to do with the club. I wouldn't want it to be fresh panel, fresh instructions, fresh language on the petition and report, and more importantly, report of a commissioner. And it's like that 2017 file never happened. It happened, but that crazy part of that file never. I don't want any involvement with that process.
Yeah, no, I understand what you're saying. Guess that was, making sure that was a question in mind. How is that to be captured with some degree of accuracy without the appraisers? This is just the question or suggestion. But the viewing is different because of the current construction, and I understand it's not limited to that construction and that is something else. But, I mean, other than taxes paid in 2017, how could anybody get to that?
They can't. Back I'll give you a quick example. Back when we had to worry about 706 federal state tax liability. And we would have someone die. I've also had it come up some in big estates where there was an issue. There wasn't, say, actual probate, but there was a lot of land. The issue of what was it worth on the day to death of the deceased. Now we're 3, 4, 20 years later. But a competent appraiser can go back and they can give you those numbers. I don't love it, as I said earlier in my argument on this file, but it can be done. It's just a little more. But in it, again, I prefer the 2023, but not. Courts don't want that if the court believes that they'll put other statutes in.
Mr. Burns and I had some discussion about parties of possession, except for crop damages. How is that? But I understand it's a smaller consideration. How is that captured? As to what was there in 2017, that landowner and farm tenant don't have written lists. Or what happened? And the follow-up to that would be, is it a bad idea for the appraiser simply to say this value before, value after, but in considering that difference, this is for loss of the property rights, this is for what we thought crop damages might entail because of construction, because of unlimited access, however that needed to be additionally expressed. And what that does is avoid the court asking those questions that somebody pointed out, perhaps you. That was simply just explaining the award of or report of appraisers. That would take those questions on too.
I don't know without this and much support what crop damages. If the court's asking if it would make sense to the extent any of the crop owners have crop damages, it would just lift those crop damages off of 17, because that's it's fungible, it's gone, that's gone. So I don't know that we have a problem. To the extent we do, if that's the one area of the court thinks because the crops are coming on, it has to be used some sort of.
Final question about that. If to determine 2017 values, how does the court craft instructions so as anything that happened after, meaning proceeds from harvests, drought, etc., nothing can be considered after some point in time or 2018 going forward? How are there assurances?
Yeah, I think the court is putting its instructions crop damages past or present considered report of the. Yeah, we all understand this usually.
There are questions I haven't asked about this line topic that they got.
No, you're
Okay, very good.
thank you.
All right, Mr. Paul. Mr. McElwain?
Your Honor, I don't want to replow the issues. I know we were talking about crops, but I wasn't trying to be funny. I know you thought Mr. Paul Graff's very well crafted and written argument, but I have a few points. we spent a lot of time talking about bad faith, and I think it's important, but to the extent that the court may be not struggling, but pondering the issue of bad faith, I think there's a different analysis, a little bit different analysis. I don't think it's necessary under the case law to say the petition's description of the taking is effective. And it triggers the court's intervention and relief depends upon bad faith. In fact, I think the case law simply says that the statutes are strictly construed in favor of the landowner. The condemning authority has to scrupulously and strictly comply with all the procedures. And in the event that the taking is not adequately described, the proceeding is void. And then it triggers the court's discretion to enter the appropriate remedies. That's what strict compliance is not dependent, or the failure of strict compliance with procedures by the condemning authority is not dependent upon the existence of bad faith. It is a device which the court says protects against potential bad faith. That's why we don't have to put on evidence or make some determination as to what is the subjective intent, although I think we have that here. The failure to describe the tape in the petition and in the later appraiser report stands on its own ground. It doesn't require a finding of bad faith for it to be defective. And that's further strengthened by the fact that if it was contingent upon bad faith, you would have to be able to consider parole evidence. How would you consider it? You're not supposed to. You look at the description, and in this case, all of the court's questions that didn't have anything to do with bad faith begin to prove the point. It's defective. It's ambiguous. It's subjected to several meanings. If I was looking at this as a contract and just looking at the language, and that is all that we're supposed to do, I could come up with 17 different potential interpretations. That might be a little bit overblown, but several interpretations of this language. It's defective. And it doesn't require a finding of bad faith. So in that respect, I don't even think the court necessarily has to get into a bunch of analysis about how did that impact the appraisers? How did that impact the landowners? Because again, that's what the rule of strict compliance is designed. You strictly comply or you pay the consequence, and the proceeding comes back and has to be corrected. And we don't have to get into all of these questions as to exactly how did this impact, because why? The landowners and the public are entitled to a administrative process that is not tainted by any problems with the description of the taking. And if there's problems with the description of the taking, it's tainted. And if we're prohibited to get into parole evidence, we're prohibited from taking the testimony of the appraisers. There's no way that you can ever get to the bottom of what was the impact. So the court simply looks at the description and by your of the taking, and by your questions today, and all of the activity that took place in all of these cases, come to the conclusion that it's inadequately described. And now I have to do something about it. And the only remedy would be to send it back to cure the ambiguities. Number one, send it back to a new panel that is not tainted. The panel is not tainted by emails. It's not tainted by anything that went on before. And then conducts an appraisal, and then decisions are made as to appeal. Anything else requires you to get into parole evidence. Anything else requires you to divine the intent or divine the mental processes of the appraiser. And that is what the rules of strict compliance and strict instructions are designed to protect against. You don't want to get into that. And we put the burden on condemning authority to do it right. If it's not done right, then it's void. Now, I submit a little bit different of an argument, and I don't know if it makes much of a distinction, but it is void. That taking is void because that's what the water district case says. Then you go look at the city of Wichita case, and you have the ability to remand it and put in instructions, put in rulings that takes care of what I would say the parade of horribles that would occur if you strictly said at this point in time, after all these years, that the taking is void. All right, it's void, but what the law allows you to do is essentially impose kind of an injunctive relief to maintain the status quo as it now stands, the practical status quo. But from the standpoint of what actually went on, the taking is void. You get to protect. Sunflower benefits from that, although they cause the confusion. Sunflower is protected because even though the taking is void, the law allows you to say you don't have to take down the poles, you don't have to take down your structure. We're going to protect you under these circumstances, but we're still going to go back and do what needs to be done to perfect the taking. They get the benefit. And what other benefit did they get? Well, they got the benefit of the use of the right of way. They were able to sell electricity for a profit. Something else that they did is, I believe, from my reviews of the record, that they actually took these property rights, and nothing wrong with it. They actually pledged it in a credit facility to borrow money to finance these projects. Right? They got that benefit within a defective eminent domain proceeding that they had control. Now, is that bad faith? I'm not saying that's bad faith, but that is the practical effect of the benefit they received and the burden that the landowners incurred in the interim of having to dig in to a confusing situation, do their best without completing their award when they had no contract. This is a lawsuit. There's no negligence, no tort on my client or any of the landowners' part. There's no contract. We're hauled into court simply because we're landowners. Now, the law allows that. But in looking at this case, you see all of the benefit went to Sunflower and all of the burden went on the landowners. They essentially have lost a large portion of the value of their award. And that supports the remedy that we're asking for is that remand, new appraisers, everything is cleaned up, there's no taint, we do it right, and then the process takes its normal course. That being the case, you don't have to get into bad faith, although I believe in one form or the other, there is at least reckless conduct. And again, I go back and I'll say it for the last time, I talked about it this morning as to what is your role to constitutionally protect you, everything you can to protect landowners. And that is the thrust of the approach that we're asking you to do. And any trepidation on your part should be salved by the fact that during this whole process, Sunflower had the benefit of the use of the property. Had the benefit of the use of the property during this whole process. Which takes me back to the issue, and again, I think the 2023 valuation is founded in the legal consequences of what happened here. First of all, we start with the unassailable point that the description of the taking is deficient, and then under the water district case number 1 is void. You don't have to make them take the poles down. But if we're going back to the appraisal process, essentially that taking hasn't blossomed into a full taking until this new appraisal process takes place, the new administrative process takes place. So we're looking at that to give us the benefit of what we've lost over 4 or 5 years and to balance against the benefit that Sunflower had over these last 4 or 5 years, using 2023 valuations, I think is fair and reasonable. It's supported by what happened. But again, don't want to let the tail wag the dog on that, but I think that bears some analysis for it. Those are the only couple points that I wanted to make that Mr. Polgraff did not touch on. If the court has any questions, I'd be very anxious to help out.
You talked about petition being tainted. Last view difference between the court simply limiting reading the petition against the drafter being the plaintiff, limiting the rights to only the easement of construction and access. Limited, I can do that just based on my reading of the petition. It's fine that it's void, be something along the lines of statutorily deficient. And by doing so, that simply gives the court the realm of possible remedies, excuse me, and then there's some direction from the Supreme Court about what might be most appropriate. And that's once I get to that point.
As I take the court's question in bits and pieces, and if I miss the vote, stop me immediately. I think the one question you asked, Mr. Turner, said, well, can I just take what you drafted, you being Sunflower, and say, hey, I'm going to restrict everything to what I refer to as the right of way. To echo Mr. Polgraff's point, you really can't, because that affects the landowner's ability to recover insurance fees in the appeal process, because now you have redefined the taking in a way that you have no way of knowing whether it corresponds with the appraiser. So it's not apples and apples. Number two, from an interpretation standpoint, then you're kind of saying that the right of ingress and egress doesn't really make sense, because I think that effect of that interpretation would be you have the right to ingress and egress on your right of way within your right of way, and the true intent of the taking was along this larger existing tract with an unlimited right of ingress and egress. So I don't think that works. Number two, I think if you get to the point where you have to do any interpretation, to think that, okay, I guess as part of we'll amend our way out of this fiasco without sending it back to for a new and proper appraisal. I think that's where you stop and say, if I have to sit down and figure out what this means, and spend this much time, spend what'll be almost a full court day trying to figure out what this means, the analysis stops. It's deficient, because how did the appraiser? We don't know, what did the appraisers think? You have no way of knowing. So the only way to put us back to where we need to be would be to clean up and make it what it was intended. And what it was intended to do, or what as a matter of law, I think was intended to do, was it's an unlimited easement with unlimited ingress and egress over the described property, which would be the largest tract involved, number one. Number two, I also submit you got to clean up number 7. Because again, it may be on the neophyte, but I look at number 7 and it talks about you can't put any type of improvement, fence, or structure in or under or near said easement that would inhibit or impair any plaintiff's rights or benefits. What is meant by easement when the easement also provides a right of ingress and egress to gain access to the right of way? As I read that, does that mean that if I want to go construct a barn on the other side of the track, I have to go get their permission? If I'm buying that property, I'm like, what am I getting? Can I put a wind generator on the other side of that track? No, says I can't do anything. without first making a determination and essentially asking Sunflower, will that inhibit or impair your right of ingress and egress, which is already admitted to be across that entire tract? So 7 also contributes to the ambiguity, and who knows how the appraisers interpreted that. And I don't think you get into their mind. You basically, facially, it's inadequate because it doesn't accurately describe the nature of sin, specifically the nature. You can come to too many interpretations. And we can sit here and argue all day as to what those interpretations should be. All you have to determine is it's ambiguous, it's therefore void, and you have to send it back for a reappraisal.
Clarify, if it's ambiguous, and you're saying it is based on all the questions, right? Statutory effective, if the 502 opens up remedies for the court, you would remand most probably.
Yes. In fact, I think you're most appropriate, in my mind, it is the only appropriate remedy.
I appreciate why you believe that's the most appropriate remedy, both for defendant landowners and plaintiff. And when you talk about plaintiff having the benefit of what they wanted at the time they wanted in selling electricity. I mean, I'm going to try to make this a fair question, and so you answered best you can. But eminent domain is set up for the public. This benefited the public. How much of that is attributed to the public benefiting, if that makes sense? Yes, they may perhaps make profit subject to governmental oversight selling their electricity, but the whole purpose for this process is so the public can benefit from the process. So they are also benefiting, but how much, if that can be, like I said, not a fair question, but
No, I
it's
think
sufficient to simply say the public has a benefit also. That's probably primary concern, that process was being gone through, but that nobody else is prejudiced, including the public, by going that route and remedy.
exactly, Your Honor. Nobody's saying that there is public good, but there's not public good by depressing the compensation to the landowner. And there's no public good of, again, some of the work I do is tax foreclosure work for 24 counties. And I look at title work all the time. And my first reaction is, how in the world would you ever figure out who got what if I were looking at the register of deeds? That the public is protected by what we're asking. The public continues to receive the benefit of supply of electricity, and the landowners are constitutional right is preserved. And I bring up the benefit simply saying you're not hurting Sunflower. Sunflower's not going to be hurt by this at all, because they still enjoy the utilitarian and profit-driven, correct, rightfully so, benefit of the use of this property. Nothing's slowing it down. There's nothing about your ruling that's slowing it down. All we're asking is make them do it right, protect the landowners, and I still submit, like I said this morning, maybe with not enough gusto, but I hope I made my point that if it comes down to it, there's any doubt in your mind or any particle of discretion, I think the court and the Constitution requires you to exercise that for the purpose of protecting the land. And there's nothing that you're going to do that we've asked you to do, not one thing that in any way impairs their ability to do business. We're just asking them to do it right, because doing it right is designed to protect everybody from bad faith, again, simple mistakes. And that's all you got to look at is this description. We can't really tell what happened. We can't tell what it meant. You can't tell what the appraiser meant. And I also, looking at some of the files and reports in the other cases, I think one of the problems is too that this defect, the ambiguity in this permeates into the expert witness issues. And it makes it difficult to determine whether or not some of the expert witnesses have actually done a good enough job for their opinion to be admissible or at least constructive. And it becomes more of a wild west based upon you really have too much, I want to say wiggle room, but there's too many spectrums of outcomes that flow from this ambiguous description. And anytime you have an expert saying, well, you know, they're really not going to use it for that, they're only going to use it for this, there's the problem. And if you were worried about what's going to happen with a jury or a verdict, it's that paint is seeped into those expert analysis. If you're going to set a trial, you have to figure that out when you shouldn't have to. We shouldn't have to.
Talking about, I'll only have a few more questions. Talking about the benefit who might not or might be prejudiced. You understand what you were asking for as the most appropriate remedy in false draft, and to some extent, Mr. Stout, Mr. Kaplan, though they go farther. That allows, well, if you're telling the court it should not simply limit the easement or limit the taking to the easement for all purposes, that remains on the table the landowner's exposure to 360-degree access on their larger tracts. The remand is for that purpose as well.
I believe so, because we're saying it's unlimited. The ingress, egress is unlimited. That's what we believe is the problem with paragraph 6. Also, the described property, in my mind, it may be that I just don't have enough experience, but coming in it cold, there's a problem with what is the described property. I think that needs to be firmed up, and there needs to be some more definition to make sure that everybody understands the impact of paragraph 7 as it would relate to the 360 access that you just described.
So that
Because that's the maximum taking.
that's a consideration that council's gone through and your clients have gone through in coming up with these recommended courses of action. Of course,
From my perspective.
yes, from my question. Fun question, and you provided an excellent segue in your tax foreclosures, tax sales. There's some differing authority, certainly authority that's different, inconsistently applied. Who pays the taxes on the property after the taking? Even the easement, strip of easement, where all the construction is, such that the landowner probably can't enjoy that portion of his ground, his or her ground, like he could before the construction. The landowners continue to pay taxes on it.
My understanding is the tax would go with the fee interest. And if I own the fee subject to, you know, federal states, and I've given away the states to the right of way, that as I have experienced it, that primarily that rests with the fee owner. But I may be wrong, but I believe that's the law, rests with the fee owner. Because when we sell property tax sale, the statute says you're selling it subject to easements and use for the record and rights to possess with the property. So I think that's the outcome. But I would have to go back from that as I stand here, I believe that's the case. Because when we get our title work, I've never had a distinction. It just says subject to this right away. Railroad reference to subject to this preferred right, and there's not specific. It may go into the other. It may go into the appraisal, the tax appraisal for the property that is impacted by the right of way. Mr. Ballgraf does tax appraisal too. Am I right? I'm right. Okay.
But I'll give council an opportunity to respond if they deem appropriate. That's not at least expressly said or expressly considered in any of these statutes.
No. Nothing I know.
For purposes of tailoring or limiting or making sure it's not too broad.
Right.
That's just simply a residual
impact.
Thank you, sir. Mr. Stout?
Ready, Your Honor?
Yes, sir.
I'm interested to see if I can say anything new or different on either challenge.
I would bet in favor of that.
All right, well, I'll leave alone a bit of wrangling over the language. I think that's been pretty well settled. It is unclear, if it weren't, then we'd all be in agreement by this much discussion of what exactly is taken. Let's take a minute and say this morning, I heard my client wasn't named in part because 26502 says only insofar as their interests are being taken. And so parties in possession were not named in this lawsuit if they were known. Now, let's see if I got this right, because we knew who I was. The petition actually names all unknown parties in possession, but the known parties of possession were left off because they weren't taken. Okay, what's a possessory right? You've got a right to be on any part of the property. So Mr. Klossmeyer had a possessory right to this piece of property out here. And it was taken because that property, if nothing else, the dominant right, according to the first sentence of paragraph 7, the dominant right is the right of ingress and egress. So if Mr. Klossmeyer comes in and plants wheat here, he is possessing that property with his wheat crop, right? But when they want to come across it on track 13, they destroy it. Well, but they don't destroy it. Don't worry. Mr. Klossmeyer is given the right for compensation where in the condemnation in which he wasn't named. Oh, okay. So we have a possessory right, and we're told it wasn't taken. And I think this will go a little bit to explaining why maybe the jury saw something different than the court appointed appraisers. Court appointed appraisers were given instructions on. They were told, you assume they take the rights to the fullest extent possible without regard to any limitation, stated limitation on those rights. That's an instruction. So when we're told there was no possessory right taken, is that because the existing poles are south of the section line? That section line? There was in one of the reports that says the appraiser looked and said, and besides, the poles aren't even on the property. Well, okay, but they took the right to put the poles on. In the future, they can put other on the property. When they put that in there, isn't that impacted of my client's possessory right? Or does he get to move the pole and plant his wheat? Is that what they're suggesting? That we can go down, oh, our right is not impacted here, so I'll just move this pole over, plant my wheat crop and come out. The suggestion that the parties in possession weren't affected is incorrect. That just isn't working here. So now we know it could retract the process. All the parties in possession were left out with the promise that they get damages in the law as a result of the term in the lawsuit which they weren't included in, which says the landowner get or get the right to compensation for the lost credit. Well, maybe they get that through the landowners. Is that how this works? And one day, Mr. Klossmeyer standing there and his right of possession is all the wheat that's knee high about now. It looks like a good crop. And they come through and they take it, drive over it, and replace it with what? The promise to pay it. So his possessory right is specifically subject to them coming in at any time, removing the way he is possessing that property, and telling him, don't worry. We're good for it. We'll pay you again. Don't worry, we'll get it. This track with this condemnation did, that I'm getting to the point is, it avoided the specific language in 26.5 that it took property, not and the process to which those landowners or those property owners were involved. Well, but Mr. Stout, wait a minute. We are guided by the deeds. We went to the register of deeds office. And we looked at the deeds. And the deeds said this. So I look at 26,502 and I look for the word deed. Just one time. I look for the word register of deeds office. I look for that stating language that we're saying, oh, the deed. What's the deed? What 26,502 is saying is, we don't care necessarily what just the deed says. Because being realistic, we don't know what's out there. We say party in possession, we may mean Sumner, the farmer with the wheat crop. But we also may mean Sumner, the guy who adversely possessed the property for 14 years, 8 months when he filed the deal and had become the party owner by adverse possession by the time he filed the report of appraisal. That's what we mean. And besides, we're not here, we're not setting up a quiet title action. We're not setting up a battle to find out who's the ownership. No, we don't care if it's owned by one guy or 10 guys or 15 guys, as we heard. Made the statements we heard this morning. Ownership doesn't add value. The family farm in Chase County that's gone from the generation of 2 people to the generation of 5 people and soon to the generation of 12 people didn't gain value just because the ownership numbers changed. The ownership remains the same. But when we apply the formula as this act is intended, the due process that this act is intended to give, it begins with this question. What's the fair market value of the entire property immediately before? I don't care who owns it. I don't care. You're supposed to look at the highest and best use when you determine that. Highest and best use doesn't matter who owns it. And maybe there's an oil and gas well out there. Maybe there's somebody leasing it. Maybe there's a life estate in the property. Could be, this pie could be sliced in any way. We don't care. What's the highest and best, what's the fair market value of the entire property? You get that. What's the value after? The difference is the award that goes in, all those interests attached to that award when we go into 25/6/17, and we do that. That's when we settle. That's when the court would want to know, is this adverse possession, is the deed right, or anything like that? How am I, the court would say, how am I supposed to divide this money up appropriately? Who values the state? Who deserves that money? Not at the level we were at. The key is here was we're trying to make the pot. We didn't do that. We left out everybody who had a possessory interest, and we created tract 13 out of whole cloth. At some point, I don't know if it's flowery. I would know if we walked into the door. But at some point, they prepared this exhibit. Right? This is supposed to be a marketable piece of property. This is tract 13. Then they put it there. It isn't even tract 8, 9, 10. It is 8, 13, 10. Why? Why is this thing stuck over there? And nobody said, when we're filling out this petition, nobody said, fellas, what's this? This is Phil. What's going on here? So all this goes to one thing. The process is void. Not because we didn't do anything, not for this, but because it didn't meet the process. The Fifth Amendment to the United States Constitution, if I may. I think that enough for everybody that needs to have one. So look what it says. There's 2 things. The Fifth Amendment sets a standard that we need to recognize. First of all, how important is what we're doing today? There are only 3 things that the Constitution says get due process. That we will not deprive people of without due process of law. They are your life, your liberty, and your property. Property is as important to the founders as liberty and life. It is a significant right that we must protect. And how are we going to protect that? We're going to have a process by which at the end of it results in just compensation. Okay. So Kansas said the eminent domain procedure act is that process. First, I don't care about deeds, I don't care anybody who has an interest in that property name. Bring them in. We didn't. The process says define what it is to pay, what it is you're taking. You want to know why? Because we want to have a firm idea, firm measurement on what just compensation should be for. And we're going to adopt another rule. So if they describe something, take it to the fullest extent possible. Because they have the right to limit it. And they chose not to. Well, yeah, but see, they said reasonable. Don't you see, that's reasonable limited. And reasonable, we ought to be comfortable with that, because after all, we've all been seen the criminal. We took criminal law, or we were involved in criminal law when we graduated. And we know there's a reasonable standard. But every time we did that in reason, we were looking back at conduct saying, if what he did was reasonable, shooting at the passenger train from afar, was that a reasonable conduct? We were looking at past conduct. Here we're looking at forward conduct. So we are always going to be reasonable. Well, juror number one sits right over there. They think reasonable means no big trucks. That means they'll never drive big trucks on the crosswalk. Juror number two missed reasonable, wasn't paying attention at all. Juror number three assumes reasonable means driving down the right of way. We're weighing all this against the 3/4 point of the appraisers who were told to interpret it to the greatest extent possible, because they'll use that right. So they assume reasonable went all over the track at all. What we've got, again, they didn't name everybody, descriptions are not sufficient. This process is void. This process is void. Okay, so it's void, Mr. Scott, that's great. So now we've got a mess. What do I do now? If we stop there and say it's void, and we put everything back to the beginning, that means we give back the money with interest and they take down the poles. That's the only equitable way to do it. That's the only way that puts it back to the beginning. And you say, yeah, but Mr. Stout, the ice rink survives. Remember that. The ice rink survives. So how do we get around precedent when we all know the ice rink survives? And the answer is the court remanded. Now, they may have called it something else, and if this should go up and they wanted to tell me that that's not what they did, then I apologize to them. But what they really did in that case was say, an inverse condemnation action requires proof of 2 things. You must first show that you had property interests that were taken that they're not paying for. And we've done it. And in the ice rink case, the court as much as said that. And if you prove that, then the question becomes how much. So the Kansas Supreme Court said, you have a remedy against them. What's your remedy? Go get your money. They were removing the first question from the subsequent proceedings. That's tantamount to a remand. Here, go back and figure out what the amount is. Don't worry about whether or not they own the property. They did. That's what we just saw. Remand. Start over. Okay. So what that tells us is, can we remand in this case? Yes. There's precedent to do it. It's less, it's part of it's within the total package of void. You want to avoid, that's fine with us. Remove the poles, we'll wait till they're removed. That'll be fine with us. But we recognize that remand is important. What else do you require? Well, when we get to a position where we reach the conclusion and the same facts that support remand support 2 other things. They support revision. We never support attorneys. These facts are facts which show abuse of discretion. I'll go on with that far, but that's all the further I have to go. Oh, but Mr. Stetler, about sin, you gotta prove it, you gotta show it. Oh, really? We know today that they talked to Mr. Klossmeyer, who told them, that's my wheat field. Mrs. Meyer owns the 80 over there, and I own this part. And they don't name him when they create this. They create it. The legal description, look at the track 13 document. The legal description is the east side of Klossmeyer, the west side of Meyer, and whatever it takes to get us in between. I'm taking a little liberties with their description, but that's essentially what it is. We're just defining it as the stuff that isn't included in anything else. And then when we get through defining it, I know, let's name the Texans. Texans are taking a pretty bad beating today from my speech, but let's name the Texans and bring them up. Well, Mr. Stuart Lowry, why didn't you name Mr. Crosby? Wasn't taking the interest. Oh, really? You took the right to put structures on the property, and he had the possessory interest. You took the right to drive through his wheat field, and his wheat field is him possessing that property. You took the interest. So what we're seeing is at least 4 structures. So if we look at the Johnson County case, what they say is the descriptions in a petition are all the exclusive domain of the condemning agency, and the court can't sit here typically in a hearing under what is it, 26.504, where we can consider the petition and decide whether or not the legal descriptions that they're taking, that's not subject to the court's review and input unless we find fraud, bad faith, or abuse of discretion. We've got it. The same factors that result in this thing being void also support the conclusion that you can use your judicial power of review to step in and revise the petition consistent with what they were wanting to take. Consistent with what they were wanting to take. The court can't come in and say, you know what, I think that just fall. If we just let give easements up and down, drive up and down the easement, just that's all they need. It may be true, but the fact is they first said we want to cover everything. Throughout these proceedings, the biggest, the fullest interpretation of what they took was assume access across everything. We can assume, reasonably assume, that the court appointed treasury. And the first hearing, we're told they took access over everything. It's not for the court to decide whether or not they want to do it, but we can sit and review that description and revise. So we can actually define the described property. We can actually describe it. And then we can say access is unlimited. The dominant is. We can make paragraph 6 and the first sentence of paragraph 7 be consistent instead of conflicted. We can work out this. What about, Mr. Stout, you spent a lot of time talking about this track 13. Let's do this. Leave them. Track 13 and track 8 and 10 are remain the same. But let's tell the court appointed appraisers that the before property is track 8 and 13. Okay? Except this portion. We'll only condemn the property once, and that's how we are. So Mrs. Meyer Trust gets the east 80 acres. Everything else is Klossmeyer. But we don't need to settle title issues now. So on each tract, let's do this. Let's name the Meyer Trust on the east 80. Let's name Klossmeyer. Let's name the Texan on the east 80. On the west, let's name Meyer. Klossmeyer, the Texan. Anyone else that we think might have. Then once we get our numbers figured out, we can appear in front of court for another long day in which we resolve how the money is supposed to be distributed. And if Mrs. Meyer wants to make no claim to the condemnation proceeds for the west portion of the property, she need not show up. If Mr. Klotzmeyer does not want to make a claim for the proceeds from the east side, he need not show up. The Texans are welcome anytime. I think I've made that abundantly. So the same factors that avoided that allowed the court to revise that and include a change to the description of the property. They combine two tracts, that's done all the time, so that Mr. Klotzmeyer gets the benefit of 26.513C, which says your damages will be determined by the fair market value of your entire property, not your deed in it. Your entire property immediately before, and the value of the property that remains to you immediately after. And if anybody else wants a piece of that action, they're welcome to. Okay, so first, void. Second, revise. Third, attorney's fees. We know from the Kansas Supreme Court that the definition of, well, Fifth Amendment says due process to get just compensation. And Kansas defines just compensation as the landowner being whole. So when the landowner comes in, he owns a piece of property, fair market value of which is $100,000. When he leaves, he should have a value of $100,000. It will be in the remaining property in the award, the total should be $100,000 equal to a fair market value. That's the theory behind it. That's how we make him whole. Statutes and things across the land that I'm familiar with, and routinely said if you bring counsel in with you, you're welcome to do that. This process doesn't require it. Typically, you pay it. What happened in this case is the condemning agency appealed. And so now we've got a question. And Mr. Holgraf asked a good question. At what point did any landlord have any option to avoid this other than saying, okay, so far, uncle, I get it. How big is the check got to be for you to leave me alone? We talked about the amount of money they received and the investment in it, but who here, we've not mentioned yet, but for 5 years, this has been a big deal to allow land. We come in the courtroom and we think this is the best way to spend the Friday. Are you going to have a great time with them? Landowners disagree. I could never be an attorney on my week. Day in and day out, 5 years, we've been unable to resolve this. Oh, we've had motions, pre-trial, and we've talked. Well, right now, the access is here, the access is there. You're part of 13, you're not a part of 13. Don't worry, we'll pay you for your damages till we, well, not maybe we won't. We've gone back and forth. It's been awful. Landowners hate it. We can't make them whole there. But we can protect it so that when they came in with something that's fair market value, they leave it fair market value. With apologies to Mr. Aldrich for well thought out argument. But I would add to it is this: it's unconstitutional, not because it doesn't speak to when a landowner appeals. Because if the landowner appeals, you're fighting that, you're picking that fight, you gotta stick with it. But what about the landowner who doesn't appeal but gets shoved into this? Let's take Mr. Klotzmeyer, because we picked on him, and it's being broadcast, so everybody will want to stick with just one name. So let's say he's awarded $20,000 for his statement. All right. For 5 years, he dealt with it. For 5 years, he had to put up with meetings with Stout and Captain. You know how awful that is. For 5 years, he's done all these. And at the end of it, the jury comes back and says, well, Sunflower says, Mr. Klotzmeyer, you're entitled to $600, not $20, $600. At the end of it, the jury comes in and says, Mr. Klotzmeyer, they won't be told with family. you're entitled to $19,999. Congratulations. Well, that's wonderful, but he's hired an expert, he's hired a surveying company in order to find out that in fact, that in the legal descriptions, leave a gap and overlap. He's had depositions, he's paid for stout and capital, you know how awful that could be. But the result is, when we look and say, well, you came in with $100,000 and you left with 80 in land and 20 in fees, he's gonna say, well, now I've been forced to defend my property. And it's cost me $21,000. So now, that is where 26509 is unconstitutional. Because it doesn't preserve that. At least my take on this report, also. But I don't think we need to go there. What we've established is conduct which justified voiding and revision. What we know from the Water District Court case is that there are some facts, weren't the ones in that case, but there might be some facts that would justify the court when it steps in and exercises its authority of judicial review for the purpose of administering justice. In this case, for the purpose of ensuring due process and just compensation. That's what justice is. When you step in, these are available to you as a tool to get that done. That's what the case does. Mainly I'll admit that often it's in the form of sanctions. We're not saying that right now. We're saying in order to preserve and get done what the administration of justice needs to have done in this case, the court must exercise its authority to this extent also. We are already going to exercise that authority to void or in this case review. We're already going to exercise that authority to revise. And now we're going to exercise that authority to award fees. And given that the same factors support all, the question is not, do you have authority? Why don't you? What factors are weighing against it? If you don't do it, there's absolutely no way any of these landowners leave whole. The process has failed. Because they've all spent their award defending an action they didn't want. Right? So what other way do you do it? So what's the reason not to? Well, the reason not to is, Mr. Stout, there's no statutory authority. We know in the state of Kansas, you got to have a statutory authority to award the attorney's fees. That's true, except when we actually, the trial court exercise its discretion to administer justice, which is exactly what we're doing. Well, that'd be unfair to Sunflower, really, because we've already heard that Sunflower has been the only one over the last 5 years who decided to spend money. Got the poles out, got them built right on time, start cranking the electricity. We're having a great one. They've gotten everything they want. They got a little greedy and said, okay, we want some of the money back. So, what good reason is there to not award fees? Not unfair to them. It's a small cost to them for what they receive. If you don't award it to Klotzmeyer and Meyer, my clients, and their awards were down in that range of 20,000, I guess the public, so I can say. They were what, $19,000 and $18,000. Hired a couple experts. Although we didn't ask for it, it was not the published fault. We had a appraiser deceased now, so we had to replace them and get another appraiser. We hired court reporters. We've done all this. We hired an engineering firm to get on the goods. You send us back to the administrative level, we're not going to be made whole. The only way to make us whole is to award a reasonable attorney. And it's well within the court's control. I made some notes on certain things that were said going last in the benefit and courage, because you get to make notes on what's all said, but then when you stand up, you have to be able to read the notes. So I can get it about partway there. And I can notice that there was the comment made Well, how do we compare this with the jury? Well, we have Mr. Stout, why don't we just spend it now? And if you get $1 more, voila. The answer is I won't get $1 more through administrative action, this is where this is. If you change it and take it to a jury, you revise things, you're hopeful that you were going to compare apples to apples. And what you're saying is the jury wasn't seeing the same thing that the court of public pressure. In order to figure out why the jury verdict was significantly different, you not only got to look at what they were just instructed, the extent of the taking was, but you also have to look at the testimony. Was there testimony that not to worry, the wires are 24.5 feet high? Was there testimony that don't worry, the poles are on the other property? Did they allow them to go out and look at the project? Because all that is significantly less than what was taken. And the court appointed appraisers were worried about what was being taken, the full extent of the rights being taken. So it is an explanation for why the jury found for less must include a review of the testimony that was given and the reports that were prepared. See if that testimony was at all something less than the full extent. I suggest not do that. In this case, it happened. Send it, remand it back, bring new appraisers. I say go with 2023 because it makes sense with the caveat to the appraiser. You must assume that improvement isn't there. Mr. Stout, why does that make good sense to you? And say, well, Your Honor, it's a good question. And the reason it makes good sense is if you avoid this, leave the polls up, do what the city of Wichita versus Myers did, decision does. Then when I go back and at inverse condemnation case, I'm going to instruct my expert to ignore the improvement. Because I'm entitled to the fair market value of my entire property as it existed immediately before the taking. Immediately before. You go back to tell the panel, you are to consider this property as it existed immediately before this was done. There are no poles. There are no lines, there's no right to drive over. Once we do that, we say, well, are you comparing apples to oranges when you compare 2017 with awards to 2023 awards? My answer is maybe, maybe not. But we can't solve all of it. We solve most of it. And the most important thing, the problems we solve with Mr. Falk's solutions here are that the landowners will be entitled to a due process that will give them a fair shot at just compensation. All we're doing is leveling the scale. When this is over, maybe Mr. Cosmar gets more money, maybe he doesn't. We can't keep them level at the end. Going into this proceeding, we can make it. And that's exactly how we'll do it. We have the authority to avoid and remove. We have authority to revise. We have authority to do attorney's fees. And the question is, what is the best one in all those options? We would ask for remand to the administrator for the 2023 valuation. We would ask for a revision of the statement to accurately describe the full extent of the easement rights that they taken. They have the easement rights or access rights, just like they do these, and they use them. If they're going to cross the property, I've ignored the question of access to track 13. That opened up a whole new can of worms, and we can discuss it if you like. But they've enjoyed this, so let them have it. Attorney's fee, when we award them 2 days, then that just puts them back to zero. That just levels the scale. Not a benefit, not a reward, not compensation for the 5 years of agony of having to go through this process and put up with stop and gap. That may not be compensable, but it makes it easy. And it's just want to be patient. So, Your Honor, you have had questions from people before. We're at the end of a long day, and I've gone on way too long. If there's any questions, I'd be happy to.
Well, you know I do. So Here we go. Generally, your arguments are about Klossmeyer not being noticed up for track 13 as a party in possession. I understand that's the most extreme example that you have.
Yes,
But those are, I assume, are those arguments also being applied as to track 10 for purposes of what the appraisers consider. I understand track 13 separately diminishes or at least affects track 8 and track 10.
well, the track 13, the decision to say, I got it, I'll solve this deed problem by just driving this, creating some problems that need to be corrected. First of all, Mrs. Meyer, or whomever we want to say has an interest in track 10, is entitled to 26,513C, which is the value of the entire property immediately before. If the Court of Planning Appraisers understood this problem, then how did they handle valuing the same piece of property twice? Do we have any confidence that this whole thing was handled correctly? Because if you have, the administrative proceeding is in front of appraisers. With all my respect for them, it's not a good place to grade legal. In fact, that's probably why the court's instructions do them and say, if you have any other questions, come back and see me. So track 10 doesn't work either. Track 8 doesn't work. Our solution is East 88, everything in 2 tracks. You can call them 2 tractors, track 8 and 13 combined. And then name everybody, and we'll remove, create this. The county. This is the representation of the information that their appraiser relied on when she valued the property. She went to this source, and this source sees no gap, right? So this is nothing unusual. This is what we're saying, it can then, we'll sort out that Sunflower can build their power line, oh wait, excuse me, they already built it. The power line can remain. And any title issues we can clean up in due course. Okay.
Reasonableness. And more than one council touched upon criminal aspect, and that has me thinking. In the criminal aspect, when somebody's asked to apply reasonableness, that is to a defined act or action that's already happened. In this context, not only in a jury trial, and I certainly understand and appreciate what you're saying, that the appraisers should have considered the full extent of possible use for the property. But in the instructions to the appraisers, it also has reasonable in it, or reasonable.
Mm-hmm.
As you've pointed out, that means different things to different people. And so how is there any unanimity of the jury when those are competing standards for the jurors? If that makes sense, that their reasonableness could mean more value. And so it's questionable that reasonableness, reasonable shows up in the appraiser's instruction. How that's applied. How is it consistent to a jury panel of 12 persons, even if the language is exactly the same, and it was not, or I don't think it was in the other 2 cases, whether it should be or etc. It seems to me that's 15 different interpretations of reasons based on your argument.
That perhaps, but with respect to the instructions to the Court of Planning Appraisers, I believe the court is right when it says the term reasonable shows up in there. In my recollection, standing here today is, it's in the context of the proposed use of the property. Provided, however, any proposed use of the property must be so reasonable as to impact current market value or something like that. You have an impact on its current value. So what you're asking the appraisers to do within that context is measure an existing circumstance. All right. If I had showed up with Mr. Klossmeyer's tract at the administrative level and said, fellas, this land is worth $20,000 an acre because we're going to build a hotel and casino. And that's what we're going to do with the property. The answer to that would be, that's not reasonable. Nobody goes into the market and looks at this ag land and says it carries a price because the potential is hotel and casino that stretches one. But in my example, the point is, those court-appointed appraisers can look at something that exists now that is current and say, is it reasonable to make that assumption? In our case, we will argue, and you heard us, that that the value of the Klossmeyer property has an element to it that value that reflects potential rural residential. Some are objected to it. What was our response? How did we respond? Oh yeah, look around the area. Remember, we had a bigger map with an area, and we could count within 2 miles. We could count to 15 or 20 rural residential evidence of an existing fact. It is reasonable to say that an existing fact shows. Now, let me ask you, Your Honor, this access in the future that's reasonable. What are the existing facts right now that tell you what that's going to be? How are they going to come in? Big truck or small truck? Drill, tow truck, 2 trucks at a one? Perhaps it's aerial flag, drone. So they're going to drive this. Maybe it's a drone in a truck. Maybe it's 2 trucks. Maybe they come in on horseback. How much of this is reasonable? Your question to me is, I don't know. What did they do? Did they drive 10 trucks in at once, get out, tighten the bolt, drive 10 trucks off? Did they have a line down, bring in 10 trucks and get it hooked back up? Maybe that's reasonable. Right? When they say reasonable, what they're really saying is, in exchange for this property right, you had to exclude us. We're going to give reasonable access, or in other words, we're going to give you the opportunity to sue us whenever you think we push the edge of the envelope too far. Or argument. I don't want it. We have at least, we can say, we don't want that. And that's all the more clear it is. However, in the instructions, we will talk about something specific. Does the proposed use reasonably impact the fair market value of the property? We said rural residential. Yes, it did. The jury can, based on current fact, make that decision. And so I think that, I'm sorry, I'm going on to, so I think that's the distinction.
And I will say, Mr. Turner, we'll finish with Mr. Steddow. We'll take a brief 10-minute recess, so you don't need to anticipate me going right back to you.
That's unreasonable.
Any any emphasis placed on 26502, where it says the name of any owner and all lien holders of record. And of record being the operable term that I'm asking about.
Right.
But what is the emphasis to be placed on that?
Well, I think the emphasis on that is as I suggested. What they're saying is, damn, note that they said any owner. So the deeds, life estate, doesn't matter, name it. Lien holder, mortgage, what other rights or property, lease, oil and gas interest, any, name it, right? It's not considered exclusive. It's supposed to be exhaustive, right? Go in there and find out everybody who has some claim to this. In some counties, they name the county treasurer, that they might have a lien for property. Name them. Got a party in possession, whether it be immediate possession or adverse possession. Name them. We're not asking you to turn, we are not turning eminent domain into a quiet title action. No. What we want is a procedure that gives the landowner due process and gives the condemning agency a relatively prompt judicial process to get them on the property and get them done. There's a benefit to it for the condemning agency as well. Follow the rules. You get on the property in 90, 120 days at most. 20 days to file a petition, point of creditors, 45 days to answer, 30 days in which to pay into court. Boom, you're on. Right? If there's an argument over the value, you still go on and we go down the road fighting. But that all assumes we follow the act. You want those benefits? You got to bear the burdens. And we didn't.
Yeah, I understand that. I understand your position, naming more is better than naming less. I mean, operable words of record, where else would those be noticed or expressed than register of deeds office is similar.
Well,
those seem to be a primary concern because that's the actual language of the petition.
Right.
I'm sorry, the statute. But it seems to me that it's reasonable to say, well, everybody's register of deeds office should be named. That would be a place of record for purposes of notice of our liens, for notices of our ownership. Where else would that of record apply?
well, they didn't come out and condemn us. It was the first time they were in Sumner County. They didn't say, oh, condemn us stretch land right out here. They've been out and looked at it. 26/5/12, I think. I might be wrong on that. A prospective condemner or its agents may enter upon the land and make examination surveys and maps thereof, and such entry shall constitute no cause of action in favor of the owners of the land except for actual damage. So presumably they came out and examined, surveyed, and mapped the property. They knew the elevation. They knew what the quality of the ground. That wasn't their first time. And when they were out there, they might have looked around and said, I believe this would all be informed by the same guy. I know that because we've driven across his wheat field all the way to get here. No, or there is no pie-shaped track here. Right? They might have seen that and said, okay, we've seen it. In this case, we know there was conversations between their surveyor and Mr. Clausen. But that's all expected. We give you the right to go out and study it. That means when I'm a landowner and I see you out doing those things and I say, get off my property, you don't have to. I maintain 26/5/12 is a taking, but that'll be for another day. Okay, but right now we just need to know it. So where are the other places to do it? There. I don't know this case. I'm about exhausted. I took part of the warning for patients.
Final question, and you, thought I asked a bad question, but you provided an answer that allowed a segue. You said 26/5/12. So the court follows the recommended, your recommendation of void, revise, attorney's fees, etc. Does that, how does the court make sure, if it can, no action in tort or inverse condemnation comes in for the period between the filing of the petition and the new appraisers? If it can. With that statute in mind, you just said.
I don't know if 5/12 provided many, and I'm trying to think of the petition I'm gonna do. It's to those guys for being on my property illegally. Isn't that what? I'm so far out of law school I can't hardly remember it. But what's the definition of trespass? I'm there without permission or something, or I claim a right. But under the statute, they paid money into the court. We got it out. The question became the extent of it. It's only then that we realized the proceedings were void. If you void it, then they got to get off. So it's not necessarily turn off the void opportunity. Yeah, I still like that and would enforce it. They got to get off our property, but the court isn't saying they're under illegally. They're saying the process is declared void as of now. Anything prior to that, well, they were under claim right, at least. And I say that and I'm hesitant because I know they made the promise to do some pay for damages when they were on the property, and I don't know that all those claims have been resolved. And so to the extent there are those damage claims out there, nothing we're doing today is changing that. And nothing we're doing today is setting them up for any sort of claim because the poles are out there and the power lines out there. In fact, if you remand, then the power lines are staying. Right? And we're just telling the treasurer to ignore that. So I don't see it.
Understood. Okay, let's all question after Mr. Stout, like I indicated, we're taking a 10-minute recess. I've got,
Thank you.
12 after, we'll reconvene at 3:25. We'll be off directly recess to that time. Thank you.
Good. Yeah. 4 hours.
I'm getting paid by the hours, the rest of it, not.
Yeah.
Going back on the record, Sumner County District Court, we're addressing 2017 CV117, CV118, CV119. Clark, Kendra, Osmeyer, Meyer, appearances remain the same. We're just gonna have a short recess, and we'll finalize today's efforts. Mr. Ernest, I guess what I would suggest is you'll have the opportunity to respond to whatever you deem appropriate. Council will have the opportunity to respond to that response, and if they do, you'll have a final word, though that last final word won't be able to go into anything extra, if that makes sense. Sufficient? Very good. Go ahead.
To clarify one thing on the record, Mr. Falcraft and his clients mentioned the request for admission. And I don't know if you recall that, he's attached to an exhibit. What he failed to mention, when he failed to attach as an exhibit, would be the interrogatories where he asked to explain if you deny. And our explanation was we denied that request because it's still subject to reasonable interest. As you hinted at, you look at reasonableness in the criminal law context when you're talking about an act. We'd submit a report that the act here would be the ingress and egress. And apparently, for all the argument we've had, it's pretty limited on what they actually disagree with in the petition and language. They disagree specifically with reasonable and submit to the court that it should be just submitted as unlimited, because that's what they believe it is. That's what they interpret. They offer you no other interpretation for the actual language of the petition. Mid Kansas and Sunflower was the only party that actually said, here's what the interpretation we believe is. And that was the only guiding force the court had, other than its own opinion and its own ability to look in. Sticking with Mr. Falcraft and the Polaris defendants, they specifically make an argument about Kansas Constitution for attorneys. Not to pull back the law school, I know it's trouble on Mr. Stout, as he admitted. But the American rule has been around since the founding of the colony. The American rule requires each party to pay their own attorney's fee. Absent the legislature creating statute. That rule came into existence prior to Kansas becoming a state, prior to Kansas adopting the Constitution. Our profession's been around that long, and people haven't liked paying their attorneys that long. Had the Kansas Constitution and the founders of the state chosen to, they would have included the term together with costs and attorneys. That is not a means to actually allow this court to award attorneys. There's a mention by Mr. McElgun that the ambiguity flowed to the expert. I submit to the court that that ambiguity that he's claiming is just reasonableness. And real question, well, how did it flow to your expert that your opinion is this provides unlimited access? It came from the attorneys ignoring the word in a written document, and specifically the word reads. Didn't want to get into this issue with the court, but you've been called a big bad corporation essentially in pleadings. And now it's slides up. We've enjoyed the profits. Okay. The Sunflower Electric Power Corporation is wholly owned by Member Distribution Co. It's a 504 nonprofit corporation that is wholly owned by rural electric co-ops. That the costs of those co-ops go into the ratepayers. Our board consists largely of members of the member co-ops who own us and citizens. Their boards consist of citizens. While there is money being made, or at least money being generated from these facilities, it's not as if we're Westar. This money is, we're not a shareholder-owned company. Money is not going back in profits for share buybacks or dividends to our shareholders. Wait for my last word unless you have a question.
just only that does the American rule. That applies and nothing else comments on it, but statute. Contractual provisions, that doesn't.
Correct. The American rule is each side pays their own unless the statute or contract provides for it. Essentially, we deem the statute provided for it as the legislature saying, okay, we'll allow it in this context, which they've done in 26.5.
Understood. Thank you. Ms. Paul,
The court is extremely patient, will stand on us.
Same, Your Honor. Thank you for your patience today.
Mr. Dunn.
We'll do the same, Your Honor. Thank you.
Mr. Dunn.
I have not done.
Okay. I think all I can say today is that, of course, it's going to take some time to digest, draw lines, if you will, between what was said and what authority might say. Court does not, that first counsel should not rule out the possibility of possible findings of fact and conclusions of the law being proposed by the parties. Though I'm not asking for or ordering that today. Like I said, I want to digest and see what questions I might still have, and that I might need help and guidance on from the council's perspective. Mr. Furnace, I will ask you to start the order setting aside pretrial orders. Well, that makes you do 3 different ones. Is that an unfair request that you start and allow counsel to review for perspective of the case?
That's not unfair.
Covered everything on my notes. I appreciate everybody's time. I hope, though I'm not sure everybody had as good a time as I did today. I appreciate everybody's presentation. They certainly helped. I appreciate that we had an opportunity to address what's been, or perhaps lingering or boiling, or at least underlying since early on in these cases. Well, council just want to wait till I set some sort of status date and time. Do we want to set that now for calendaring purposes? I think we wait. I agree. Mr. Stroh. Okay. Everybody have a great weekend. We'll be off record in recess. Thank you. You guys been working till midnight tonight, or enjoy yourself?
And everything, I won't be, years ago, none of that, like, I finally worked out, I have that next day, I worked like cleaning for 3 years. It's there. And I was awesome. Your kids too. Take care.